With the consent of the other side, I would like to mention item number 10, Lordship, in the next block of the Lordship on 12/9. 10. Number 10, Lordship.
You are for the appellant.
Yes,
Item number?
No, I am for the respondent.
Item number
10, Lordship.
10.
10.
You are not in 10. What is the case number?
MFA, Lordship.
MFA 23. Okay, okay.
Number 10, Lordship. I am for the respondent.
The other side has agreed
Yes, Lordship.
on request of learned counsel for Mr. A.R. Agarwala, learned counsel for the respondent in MFA number 23/2011 and cross objector in cross objection number 2/2022. Let this matter be listed before the ensuing Lok Adalat
Scheduled to be
on
held on
12th
12/9.
to be held on 12th of September. He submits
12th of sir.
12th of September 2026. He submits that the learned counsel for he has informed regarding his prayer to the learned counsel for the other side, who does not have any objection to the same. Stop. Yes.
Please move. Yes, sir, item number 23, Lordship. I am for the appellant, but name of my land friend has not been shown in that holy. So,
Who is for the respondent?
I am for the respondent. Respect for order of the
Heard Mr. A. You heard Mr. A.R. Agarwal. Also heard Mr. R.K. Batra, who submits that today in the cause list, the name of learned counsel for the respondent, Mr. R.K. Batra, has not been reflected there. As such, a prayer is made for listing this matter on some other day.
Lordship, earlier there was order, Lordship, on 25/3/26, Lordship, to shown the in spite of the order of this honorable
Now,
court.
the registry is directed to reflect the name of Mr. R.K. Batra in the cause list as engaged counsel for the respondent insurance company and list this matter again after 4 weeks on a date to be fixed by.
May please, my lord. Item number 17, my lord. Matter may be adjourned today and fix is 11 September, my lord. Item number 17, my lord.
You have
Here,
informed the other side.
already in telephone, man, over phone, my lord.
You have informed.
So,
He has no objection. You are his.
She fixed on 11 September, my lord.
No answer to my query. Have you informed the counsel of the appellant?
I have already informed, my lord.
You have informed. Heard Ms. R. Kalita, the learned counsel for the respondent, who prays for an adjournment. She submits that she has informed learned counsel for the appellant regarding her prayer for adjournment, who does not have any objection to the same. List this matter after 3 weeks on
11 September, my lord.
no fixed date. After 2 weeks on a date to be fixed by registry.
As is item number 8 and 9, madam. I am in 9, I am appellant, and in 8, my friend is appellant for Arunachal Pradesh. I am part of Pradesh. In this case, madam, we have noted our slip for adjournment, madam, because just we have received just paper book for yesterday, madam. So can it be taken up in 3 weeks?
Heard Mr. What is the name? H.
I am M.K. Mishra, madam.
Heard Mr. M.K. Mishra.
Respondent in item number 8.
The learned
and
counsel for
appellant. 9.
respondent in RFA number 138/205 and counsel for the appellant in RFA number 140/2005, who prays for an adjournment. Also, Mr. R. Chandran, A. Chandran, learned government advocate, appearing for the appellant in RFA number 138/2005 and respondent in RFA number 140/2005. He does not raise any objection to the prayer, hence the prayer is allowed. Let this matter be listed after 3 weeks on a date to be fixed by registry. Yes.
Lordship, I beg to mention item number 20, Lordship. Kindly matter may be adjourned and fix any other date, Lordship. Maybe fix after 3 weeks, Lordship.
My lord, I am appearing for the respondent in this matter. There is a stay operating in this matter. I am unable to go for execution. My lord, if any date may be fixed, I do not have objection with the adjournment prayer. There is certain personal difficulty of his people.
Heard Miss
N. Sharma.
N. Sharma, learned counsel for the appellant, who prays for an adjournment on the ground of personal difficulty of the conducting counsel for the appellant. Also, Mr. D. Rathi, the learned counsel for the respondent, who does not raise any objection. Let this matter be listed. The prayer is allowed. Let this matter be listed on 10th of December.
Much obliged.
May I please your lordship? Lordship, I beg to mention item number 24, lordship. Senior is out of station for his statement. So kindly adjourn the matter, lordship. I have taken the concern from other side, lordship.
Heard Miss
S. Sud.
S. Sood, the learned counsel for appellant or respondent? Appellant, who prays for an adjournment on the ground of personal difficulty of the conducting counsel for the appellant. She submits that she has informed learned counsel for the respondent regarding her prayer for adjournment, who does not have any objection to the same. Hence, the prayer is allowed. Let this matter be listed after 3 weeks on a date to be fixed by registry.
Obliged, lordship.
May I plead your lordship? Lordship, I beg to mention item number 22, adjournment for 2 weeks, my lord.
22.
My lord. I have read from this other side, CDC council, my lord.
Heard Miss L. Wazida, the learned counsel for the appellant, who prays for an adjournment due to personal difficulty. She submits that she has informed learned counsel for the respondent side regarding her prayer for adjournment, who does not have any objection to the same. Hence, the prayer is allowed. Let this matter be listed after 4 weeks.
May it please the lordship. Lordship, I beg to mention item number 26. Kindly this matter may be adjourned for 2 weeks, lordship. Lordship, I am appearing for respondent claim. We have no objection, lordship.
Heard Miss M. Sakya, the learned counsel for appellant, who prays for an adjournment on the ground of personal difficulty. Also heard Mr. A.U. Ahmed, the learned counsel for respondent number 1, who does not raise any objection. Hence, the prayer is allowed. Let this matter be listed after 2 weeks.
Learned counsel, Mr. R. Goswami's name may be reflected in the first list, lordship. His name is
The
not.
registry is directed to reflect the name of Mr. R. Goswami as engaged counsel for the appellant in the cause list henceforth.
Obliged, lordship.
May it please the lordship, I beg to mention item number 18. Lordship may kindly adjourn the matter for today on the ground of personal difficulty.
18.
Lordship,
Heard Miss D. Goswami, the learned counsel for the appellant, who prays for an adjournment on the ground of personal difficulty of the conducting counsel for the appellant. You have informed the other side?
lordship,
She submits that she has informed learned counsel for the respondent regarding her prayer for a adjournment, who does not have any objection to the same. Stop. Hence, the prayer is allowed. Let this matter be listed after 4 weeks on a date to be fixed by registry.
obliged.
May I please your lordship, with the consent of the other side, I beg to mention item number 21 of the daily court list, your lordship, for adjournment.
What is your name?
H. Kaisop. H.K. Kaisop.
You are for?
I am for the petitioner, your honor. C. Fukon.
Heard Miss H.K. Kashyap, the learned counsel for the appellant, who seeks an adjournment on the ground of personal difficulty of the conducting counsel for the appellant. She submits that she has informed the learned counsel for the other side regarding her prayer for adjournment, who does not have any objection to the same. Stop.
Lordship, let the matter be fixed after 2 weeks.
Hence, the prayer is allowed. Stop. Let the matter be listed after 2 weeks on a date to be fixed by registry.
Oblige, your
Appeal loss. Well, in this case, the petitioner is a my lord religious teacher of a madrasa lordship. My lord, as a counter of a murder case lordship, FIR was lost, court case FIR was lost against the petitioner's lordship. And in that case, my lord, charge sheet is submitted lordship, showing him absconder lordship. My lord, your lordship will get find the charge sheet lordship relevant page is at page 84 lordship. The page 84 is the relevant page of the charge sheet lordship. Many years 15 accused persons were my lord charge sheeted lordship. The petition page 85 lordship, name of the petitioner Alam Maulana lordship. This is a cross case lordship in as a counter of murder case lordship. In that case also my charge sheet is submitted lordship against other groups lordship. Now 103 in that case lordship. Now against him against the present petitioner, my lord, charge sheet is submitted under section 109, my lord. That is, my lord, absolutely tribal by the court of learned sessions as lordship. My lord, on receipt of the charge sheet lordship, learned court
109 BNS.
lordship.
What is 109?
My lord, attempt to murder lordship.
Okay.
This is a tribal by learned sessions as lordship. Now cognizance is also taken, my lord, at page 91. Lord.
What is the status of the trial?
My lord, status, my lord, the appearance stage lordship. My lord,
What is the status of other accused persons?
my lord, other accused, my lord, some were arrested, but they have been granted bail, lordship. Kindly see, lordship, at page 91, the cognizance order. I'm sorry, lordship, yes, lordship. At page 91. Second paragraph, lordship.
Who are on bail?
My lord, the my lord, initially someone was bailed, my lord, to the my bail was granted to the my lord, other accused persons, lordship. At page this is upon perusal, my lord, at page 92, lordship, order dated 6/5/2026, lordship. '92, lordship, annexure 8. Now,
How many accused are on bail?
my lord, they are not in jail, lordship, arrest bail, lordship.
How many of them are on period?
Sorry, lordship.
How many accused persons are on pre-arrest bail?
My lord, nobody, lordship. They were already, my lord, who were arrested, lordship, and earlier granted arrest bail, they were, my lord, released by the learned court below. They have appeared, lordship. Now the petitioner wants to appear, lordship.
No, answer to my query. How many accused are there total?
Total 15, lordship, as per
How many of them are on bail?
as per charge sheet, lordship.
Listen to my query and try to answer to my
Yes,
query.
lordship.
Out of 15 accused persons, how many are on bail? And how many are in the jail?
My lord, in jail, my lord, nobody is there, lordship. Now, in at the 94 lordship, it is the order is there, lordship. My lord, 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13 have been granted bail, lordship.
13 are on bail.
Lordship. Page 94, lordship, first paragraph, lordship. Now, the petitioner wants to, my lord, appear, my lord, but because, my lord, because the learned, in view of section 232A, lordship, my lord, there is apprehension, my lord, they would be arrested, lordship. Now, this honorable court, lordship, other cases, lordship, liable as assessors as lordship. Kindly see,
BNSS.
my lord, at page 99. Page 99, lordship, your lordship's order, lordship. In case of absconder accused, lordship, someone was issued, lordship, on view of section 1209A, IPC, sorry, yeah, CRPC, lordship.
What is the corresponding provision in BNSS?
BNS is 232A, lordship.
232A.
A, lordship. That is, in view of that, my lord, CCM has no power to my only committal power, lordship. In that view, lordship, I have a
Propan.
The entire investigation is was absconding. The petitioner was from the 6 years old as an absconder. But earlier, the trial for 98 case, case number 98 also. It is revealed from the case that including the statements of the witness recorded under section 180 BNS that there are sufficient indemnity witnesses against the present accused persons. And earlier PRS bail petitions are accused person, namely this petition also. And so lordship, Ali had been already been rejected by the learned and citizens of recovery. My order, considering the materials from record, the nature and gravity of the offense, it appears that the case is not fit on the privilege of PRS and the accused person. They have been so absconders in the suspect lordship. So at this stage, lordship is a
Now, my lord,
the record also.
now, my lord, your lordship granted bail to the accused in murder case, lordship. This is 109, lordship. My lord, attempt to murder, lordship.
No.
Now, your lordship's, my lord, order under section 2, my lord, under BNSS, lordship, 103, kindly see, lordship. Case 103. Another case, lordship.
No,
That's
you
a-
don't show me other cases. You show how you stand differently from the 13 accused persons to whom bail is granted.
They were arrested somewhere, some parts
But
of them were arrested.
your bail was, your anticipated bail was earlier rejected by
Rejected during investigation. To the
Sessions
lordship.
Court.
I appeared, my lord, I approached this honorable court. I was not absconder, lordship. Even then, I was shown absconder, lordship. I want to appear, lordship. My lord, the bailable, subsequently bailable warrant has been issued, my lord. But in view of section 332A, sorry, 232A, lordship, I may be arrested, lordship. So I want to defend the trial, lordship. This is a cross case, lordship, against murder case, lordship. In that case also, charge sheet is submitted, lordship, against other accused, lordship. So I may be protected, my lord. Accusation is there, lordship. Until I am, I am held guilty, lordship. I am not guilty. After trial, my lord, it will be decided, lordship. Till then, lordship, I am innocent, lordship. So for fair trial, I am a religious teacher.
Why you cannot be granted bail by the CJM court?
My lord, section 232 A BNSS lordship. The power of CJM, learned CJM is to commit the my lord, accused to the trial. Sorry, sessions, learned sessions as lordship. Your lordship has observed in the orders passed by lordship in other cases, lordship. Kindly see at page 103, lordship. Paragraph 5 onwards, lordship. Kindly see, lordship.
Yes, Mr. Sharma.
After appraisal of the record, lordship, earlier this petitioner was granted bail, lordship. My humble submission is because only the session tribunal case and he should be put behind the bar, lordship. That cannot be ground, cannot be ground for granting bail about this case.
How he stands differently from the persons who have been granted bail.
Yes, lordship. Here,
You come to page 96.
There's
90
93 lordship.
96. 96.
Lordship,
6 accused persons prayed for bail.
lordship,
All the prayer were rejected.
lordship. Learned
Mm.
sessions as lordship.
Now, what happened to other 5 accused persons?
Today I have told before this, but that's my lord.
No. What is the status? If they are on bail, you may have a good case for bail. What happened to other 5 accused persons?
They are not still, my lord, arrested, my lord. The next date is, my lord, 79 lordship of 2026 lord, for appearance lordship.
No, you stated that there are only 15 accused persons.
My lord, as per order lordship, earlier, my lord, they were, my lord, released on bail lordship. That is, the 3 orders lordship, if, as per order dated 6/5/2026 lordship. They appeared, my lord, because they were already earlier, my lord.
Where is the cognizance taking order?
Cognizance taking order lordship at page 91 lordship.
What is your name? Shah Alam Sheikh.
Alam Maulana lordship, Alam alias Shah Alam Sheikh. My lord, is page 93 lordship, council, Lanesh council, my lord, file an application lordship for some time law for the absconder lordship. Absconders lordship. My name was also there, but name is not in here, my lord, at page 93, second paragraph. Because of Wakalatnama was not executed, that is why that was rejected lordship. Then bailable warrant was issued lordship. Anyway, this is a process of appearance lordship. So my appearance on is, my lord, section 232A lordship. I'll defend the trial, my lord. Any condition may be imposed lordship, my lord, abide by. Main purpose is, my lord, is the fair trial lordship for appearance before the land trial court lordship.
Where is the case diary?
Lordship. Case there, no, lordship certificate record.
In charge sheet, what is the allegation against you? Is there any specific allegation?
84, my lord, is sheet, my lord, just it is stated that I am absconder lordship. General observation is here lordship.
Heard Mr. M. H. Ahmed, the learned counsel for the petitioner. Also heard Mr. D. P. Goswami, the learned counsel for the learned additional public prosecutor. This application under Section 482 of BNSS 2023 has been filed by the petitioner, namely Shah Alam Sheikh alias Alam Maulana, praying for pre-arrest bail in connection with PRC case number 1242/2025 pending before the Court of Learned Judicial Magistrate First Class Dhubri, corresponding to Dhubri PS case number 70/2025 under sections 109 within bracket 1 /117 within bracket 2 /115 within bracket 2 /190/191 within bracket 2 /192 within bracket 3 /305 within bracket A /118 within bracket 2 /324 within bracket 6 of BNS 2023. The facts relevant for consideration of this bail application is that on the basis of an FIR lodged on 13/2/2025 by one Musammat Rahela Khatun before the officer in charge of Dhubri Police Station.
Loss.
Dhubri Police Station. Dhubri PS case number 70/2025 was registered. It was alleged in the FIR that the present petitioner, along with other co-accused persons, assaulted who died? Naushad Ali.
Loss.
That's
Nausad
not-
Ali, no, my lord, Nausad Ali's brother loss. Died, my lord, in the other case loss. This is a counter case.
was last word. Not co-accused person surrounded the house of the complainant and assaulted the husband of the complainant with deadly weapons, as a result of which he sustained serious injuries. So, on the basis of whether anybody died from in this case also?
No loss.
No. On the basis of the said FIR. Now thereafter, the investigation was initiated, and after completion of the charge sheet, charge sheet, after completion of the investigation, charge sheet was laid under above mentioned sections against the accused persons, including the present petitioner. It is pertinent to mention herein that the name of the present petitioner has been shown as an absconder in the charge sheet. The learned counsel for the petitioner submits that the present case against wherein the charge sheet has been laid against the present petitioner is a counterplus against the case filed by who is Naushad Ali?
Naushad Ali, my lord, co-case loss in this case.
Filed by the how you are related to Sujab Ali or Naushad Ali?
My lord, cousin loss. Just my lord, distantly cousin loss.
Which one Sujab Ali had died and FIR was lodged by the other side also. He submits that in this case, the 30 number of accused persons are already on bail, and the present petitioner is also willing to cooperate in the trial. However, since offense under section 109 of the BNS is involved, which is triable by the Court of Sessions. Hence, he submits that due to embargo contained in section 20
My lord, 232A. BNS.
232 within bracket A of BNS, he may not be granted bail even if he surrenders before the committal court due to the embargo on the part of the committal court to release due to the embargo on the part of the committal court to grant bail in such cases. On the other hand, Mr. D.P. Goswami, the learned counsel for the learned additional public prosecutor, has opposed the grant of pre-arrest bail in this case on the ground that charge sheet has already been filed and summons were issued against the accused persons, including the present petitioner. He further submits that on earlier occasion during the stage of investigation, the Court of Learned Session Judge Court of Learned Additional Session Judge Thubri had earlier rejected the prayer for grant of pre-arrest bail to the present petitioner on the ground that sufficient incriminating materials are there on record. I have considered the submissions made by learned counsel for the, when charge sheet was filed,
Lordship,
learned counsel for
14
the,
to 26.
when?
14 to 26.
uh,
Yes.
it is a 28/9/2000, dated 28/9/2025.
28, 9.
339 lost. Sheet dated, sheet number 352.
So after filing of the charge sheet, your pre-arrest bail was rejected.
Rejected. Case 98.
My
It
lord,
was not
during-
there.
During pendency, my lord. Okay. My lord, by learned sessions as lordship.
So what changes, what, how,
My lord, the issuance of my lord NBW process was,
and at that time,
at that time process was not issued.
you don't have a case.
It was dated by 8/7/26.
8/7/26.
Yes.
Yeah.
Charge sheet dated 28/9.
How circumstances have changes from 8/7/26 till today? What new grounds?
My lord, from the learned sessions as lordship.
Yes,
I am before you, lordship.
but we are exercising concurrent jurisdiction. So some new ground has to be shown.
Warrant has been issued, lordship.
No.
Case is of
I
25.
can- Stop. It appears that before approaching this court, the petitioner approached the court of non-additional sessions judge Dubri by filing an application under section 482 of BNSS. It also appears that after going through the records as well as case diary, the learned additional session judge rejected the prayer on the ground that there are sufficient incriminating materials against the present accused person. Stop. This court is exercising concurrent jurisdiction under section 482 of BNSS. As such, unless any new ground is shown by the petitioner for preferring a subsequent application under section 482 of BNSS, there seems to be no justification to come to a different conclusion from that which has been arrived at by the learned additional session judge. As such, this court does not find any ground to
My lord,
issue a favorable order under section 482 of BNSS. This anticipatory bail application is accordingly rejected.
my lord, learned sessions as my lord, rejected on 8/7. My lord, first NBW warrant was issued on 9/7. lordship.
I have
This is
already,
subsequent, lordship. This is subsequent. My lord, down.
I have already passed the orders.
My lord, otherwise, my lord,
Otherwise, you have two options. Either go to the Dhubri or go to Delhi.
learned sessions as lordship.
Orders, I just five.
My lord, second, I will again appear, my lord, approach before this honorable court, lordship. That may be, some observation may be given, lordship,
No observation.
with fresh, my lord, fresh ground, lordship.
No, your prayer is rejected.
Or like that.
May please, your lordship. The IA 1958 is for condonation of delay of 86 days, lordship.
On last occasion, Lordship, on 19/8, it is held that notices are served to the respondents, Lordship. And in the meantime, title execution case is also pending, and we have submitted the stay order granted by this court before the executing court also. So it is within their knowledge that case has been filed before the Honorable High Court, Lordship.
How many respondents are there? 4.
86 days.
No, how many respondents are there? Only
Respondents, Lordship,
5.
5 respondents.
Heard Miss R. Chaudhary, the learned senior counsel for the applicant, assisted by Miss S. E. Murtaja, the learned counsel for the applicants. It appears that by order dated 19/8/2026, this court has held that the notices issued to the opposite parties are duly served. Today also, no one is present for the opposite party. Hence, this court is inclined to proceed ex parte against the opposite parties in this interlocutory application. Stop. Next para. This interlocutory application has been filed by the applicants under Order 41 Rule 3A of the Code of Civil Procedure, read with 3A, 3 capital A, read with Section 5 of the Limitation Act, praying for condonation of delay of 86 days in preferring the connected regular first appeal, wherein the judgment and decree dated 18/12/2025 passed by the Court of Learned Civil Just Senior Division Bongaigaon entitled suit number 74/2017 has been impugned. The learned senior counsel for the applicants has submitted that the reasons for delay in preferring the connected regular first appeal has been stated in paragraph number
That is in paragraph number 3.
Paragraph number
number 4.
4.
Lordship.
4, 5, and 6 of the instant interlocutory application. After considering the reasons stated in the instant interlocutory application, as well as also considering the submissions made by the learned senior counsel, this court is of considered opinion that the applicants have been able to show that they were prevented by sufficient reasons from preferring the connected regular first appeal within the prescribed period of limitation, as such, the delay of 86 days in preferring the connected regular first appeal is hereby condoned, and this interlocutory application is allowed. The registry is directed to register the connected regular first appeal and list the same for admission after a week on a date to be fixed by it. Stop. The interim relief granted on 22/7/2026 regarding stay of execution, title execution case number 22/2026 shall continue until further order. This interlocutory application is accordingly disposed of.
Obliged, Lordship.
May please allow. There is an office note, my lord, 25/8, my lord. As per the office note, my lord, service upon respond number 2 is completed, whereas my lord, notice upon respond number 1, return, my lord, answer.
Now what is to be done?
We'll take fresh steps, my lord, upon respondent number
Heard
1.
Mr. S. Das, the learned counsel for the applicant. On perusal of office note dated 25/8/2026, it appears that the notice issued to respondent number 2 has been duly served on the respondent number 2, whereas the notice issued to respondent number 1 has returned without service stop. The applicant is directed to take fresh steps for issuance of notice upon respondent number 1 by speed post as well as by usual mode within 7 days from the date of this order, returnable on 30th of September.
I'll your consent.
May it please the lordship. This appeal is filed against the impugn order dated 29/1/26 against our petition was rejected on order 39 rule 4 CPC. What has happened that we are originally not made a party in the suit, and without giving a opportunity, the injunction order was passed. The brief facts of the case is that the respondent number 1 plaintiff has filed a suit against the respondent 2 to 6 and others
What is 39(4)?
to verify and vacate the injunction order.
You are not made party in this.
In the suit. Thereafter, we filed an implement this petition. After this petition was filed, and it was rejected.
You are not impleaded as party.
At the time of filing the suit in the order of the injunction.
Now,
Now it is now I filed in petition.
are you impleaded now?
Yes, implemented.
Okay.
What has happened?
We'll issue notice.
The suit property was purchased in 2007. The plaintiff was the witness in the transfer of suit property. Thereafter, in 2014, the plaintiff has filed a suit. Because my suit property is nothing to do with the suit property of the suit. Because in 1968, the petition of respondent number 9, 7, 8, 9, and 11, Polidas in 1968
Now, why suit has been filed?
for cancellation of sale deed and for right title interest and recovery of position.
Recovery of possession.
Yes, of schedule F and E land. In 19
Schedule F and
E land,
E.
recovery for recovery position.
Who is possessing this land?
Now this respond number 2 to 6 is possessing because sale deed was executed in favor of them. And in
Who are you? Who are you?
I purchased the land from Polidas.
Which land? F and E.
Schedule X land.
X.
X.
So you are not
No connected with
connected with F and E land.
They have not filed any objection against my petition.
So the injunction order is not affecting you in
Yes,
any
yes,
manner.
it's affecting my right
How?
because it is my I purchased the land by registered sale deed and invitation was ordered in my name.
No,
And
but injunction is in respect of F and E land.
Yes, yes,
You are possessing X land.
it's excellent.
So you are not affected by the injunction order.
No, when I approached for partition and development of partition of suit land, then I came to know that the suit is going on.
Okay, we will issue notice. Heard Mr. S.R. Gogoi, the learned counsel for the appellant. This appeal under order 43 rule 1 within bracket small r read with order 43 rule 2 of the Code of Civil Procedure has been preferred by the appellant Srimati Alaka Bora Borua, impugning the order dated 29/1/2026, passed by the Court of Learned, Civil Judge Senior Division Kamrup, Amin in Ms. J case number 167/2025, arising out of title suit number 36/2014, whereby the application filed by the present appellant under Order 39 Rule 4 of the CPC was rejected by the trial court. Issue notice to the respondents. The appellant shall take steps for issuance of notice upon the respondents by speed post as well as by usual mode within 7 days from the date of this order, returnable on 30th of September.
One thing, in the order to petition, the defendant has not filed any objection. This will be noted. So, they have not filed any objection. The court has, without any objection, the court has dismissed our petition because if you see the order,
Okay, let the notice be served.
there is also
I for
for stay of the proceedings because it was should stay of the proceedings of the title suit
why?
because if the injunction order is continued and suit is continued because I'll be affected
How?
because
You are
this-
possessing
this-
X land only.
this application will become infractions
Maybe, but how you will be affected?
because I'm my land, I'm not able to develop my land.
No,
because I-
there is no injunction over X land.
No, because the all dark number 8 is a land of 100 bighas. My land is 25
Okay.
bighas.
Okay, we are issuing notice in I also. I also issue notice.
My land is, I will not be able to develop the land, construct the land. In 2007, I purchased.
Mandate delay. Let this matter be listed on 30 September. Let the notice be served.
Obliged.
The case where the documents were mainly exhibited in photocopy. I mean, the lordship had granted me time to look into the records matter. I mean, what had happened in this case, it appears that the earlier advocate was engaged. He had all the documents, and thereafter he left the case and did not furnish the documents to the petitioner as the payment. She engaged another advocate, no application was made for using secondary evidence also. Now, some documents they've been able to find out, which are some additional documents with regard to medical treatments and all. And we are trying to get some records from the Silchar Medical College Hospital, to show the injury, etc. Because everything was in photocopy. The chart sheet is there. Even the font.
So what is your prayer?
My prayer will I pray for some further time if I can try and get some documents. And then
One has appeared for the appellant on call. Mr. M. Datta, the learned senior counsel assisted by Mr. N. Uddin, the learned counsel for respondent/claimant, prays for some more time so that before he makes his submission. Some more time for what purpose?
Getting the documents, old medical documents from the Silchar Medical College Hospital.
Show the name of Ms. R.D. Majumdar. They are seeking time.
So there in the file.
No, but there's photocopies, that's a problem.
Photocopies were exhibited. That was our one of the.
There is the content photocopies exhibited, so we are trying to get at least some documents from the Silchar Medical College.
But that doesn't help them because lordship, these are of 2016.
No.
In fact, those documents are of 2016.
I want to get the documents of 2008,
Okay, let him verify.
Let me try to make an application thereafter with the lordship.
We are allowing adjournment.
Okay, lordship, if
If-
कृपा करके अगले दिन बोले तो it is easier because lordship so many cases are there we will go through the
Beforehand.
beforehand.
Yes.
कृपा करके.
I'll inform.
I won't object.
Hopefully,
to
I'll not take any further time. This. Hopefully.
Considering the submissions made by learned senior counsel for the respondent claimant, the prayer for adjournment is allowed. Let this matter be listed in December
Part heard, Lordship.
or part heard,
It is part heard.
short date. September on the 17th September. 17th of September.
Hello, apply. Lordship, here the main ground is that, Lordship, the accident was caused by an unknown vehicle. As per the FIR, also, it was hit by an unknown vehicle. The appellant company is the insurer of the motorcycle and they were saddled with the liability. That is one ground. Lordship, then uh, the compensation granted, Lordship, is relating to eye injury. Total compensation was given 6,29,000, but all these are related to eye injury, which he had taken treatment in. When I read the judgment, Lordship, that will be clear. But there was no document to show that on the date of accident he was injured in the eye. Then the bills and vouchers do not have corresponding prescriptions. Income not proved. Those are our grounds, Lordship. I'll read the judgment first. And
Yes.
in the meantime, Lordship, the original claimant has died. And his legal heirs were substituted. And the item 12, Lordship, is filed by Nirmal Talukdar. So I think that they have not substituted. So that case, I do not know whether it will continue, Lordship.
No, item 12, you are the appellant.
Oh, sorry. 11 अपना. Oh, अपनी पहले मुख्य देखो ऐसे है पहले.
Aye.
नहीं अपनी पहले देखो.
But you change sides.
Yes, he showed me this side, Lordship. That's why I was.
Otherwise, it confuses the court.
Up.
We are taking up MEC appeal number 15.
See, so for 336 is concerned, it was filed by them against the quantum and also negligence. It was filed by them. Other appeal, your lordship.
And this appeal is only for quantum,
My appeal is for quantum.
only quantum,
And their appeal is for against quantum.
as well as liability.
Negligence also.
Then
And
you start first.
That's why I wanted to, because the first point there is the person died.
Get this side.
337B. Back appeal 337. Item number 12. Three 36.
I'll read the judgment, Lordship. The facts will be clear. My appeal, the judgment starts on page 6, Lordship.
Yes.
The MSC case has been filed by claimant Sri Nirmal Talukdar under section 166 of the MB Act, claiming compensation from OP number 1 owner and OP number 2 driver of the offending vehicle motorcycle bearing registration number so and so, and OP number 3 insurer thereof, MS National Insurance Company, to the tune of rupees 40 lakhs for causing him injury in a road traffic accident which took place at Beltola near SBI Beltola branch at about 4:20 p.m. of 6/7/10 involving the said vehicle. The case of the claimant in brief is that on the date of accident, that is on 6/7/2010, when he was coming from Basista Chariali to Beltola Tinyali in a motorcycle, bearing registration number so and so as a pillion rider, when he reached near SBI Beltola branch just after overtaking one unknown motorcycle, the rider Parthapratim Talukdar applied brake and the unknown motorcycle knocked down the motorcycle from backside. So Lordship, this is the description, and this our one ground is on based on this, Lordship. As a result of which both the claimant and the rider of the motorcycle sustained grievous injuries on their persons. After the accident, the claimant was immediately taken to Agile Hospital of Beltola, but the Agile Hospital sent the claimant to GNRC Hospital for better treatment, and he took treatment there from 6/7/10 to 5/8/10 as an indoor patient. According to him, the accident occurred due to rash and negligent driving of rider of the aforesaid motorcycle. Beltola PS registered a case under PS case number so and so under section so and so regarding the accident. OP number 1 owner and OP number 2 driver of the offending vehicle did not contest the case despite service of notice, and the case proceeded ex parte against them. However, OP number 3 insurer of the offending vehicle contested the case by filing written statement. The case of OP number 3 insurance company is in brief as under. All the allegations made by the claimant in the claim petition are denied, and the claimant is put to strict proof thereof. The amount of compensation claimed by the claimant is highly excessive. The insurer also declined to accept the liability if there was any violation of terms and conditions of insurance policy, or if the driver did not have a valid and effective driving license. On the basis of the pleadings of the parties, the following issues are required to be framed for adjudication. Whether the claimant Nirmal Talukdar sustained grievous injury in the alleged road accident dated so and so involving vehicle number so and so motorcycle, and whether the said accident took place due to rash and negligent driving by the driver of the said vehicle. Whether the claimant is entitled to receive any compensation, and if so, to what extent and by whom among the opposite parties the said compensation amount is payable. The claimant has examined himself as PW1 and has produced a large number of documents in support of his case. The contesting opposite party has examined one witness in support of its case. Argument of both the sides heard, written argument filed by the claimant as well as insurance company. I have carefully perused the entire material brought on record and heard the submission made by the learned counsels appearing for the parties and decided the issues as under. Issue number 1. According to claimant PW1, on the date of accident, that is on 6/7/10, when he was coming from Basista Chariali side to Beltola Tinyali side in a motorcycle bearing number so and so as a pillion rider, and then reached near SBI Beltola branch, just overtaking one unknown motorcycle. Sri Parthapratim Talukdar applied brake and the unknown motorcycle knocked down their motorcycle from backside. As a result, they fell down on the road and sustained grievous injury on his person. After the accident, he became senseless for about 1 month. Immediately, Lordship, these, though they have said in the evidence, these doesn't have any document. That's senseless for 1 month, Lordship. That is not there. Immediately after the accident was taken to Agile Hospital, but the Agile Hospital sent him to GNRC Hospital for better treatment, and he took treatment in GNRC from 6/7/10 as an indoor patient. He has firmly stated that the accident occurred due to rash and negligent driving of the aforesaid offending vehicle bearing number so and so by its rider. After the accident, he was immediately taken to Agile Hospital, but due to his grievous injury, he was shifted to GNRC Hospital. He took treatment there from 6/7/10 to 5/8/10 as an indoor patient, and thereafter he took treatment there as an outdoor patient. He also took treatment under Dr. Virendra P. Singh, senior neurosurgeon of Indraprasth Apollo Hospital, New Delhi, who came to Gauhati on 25/9/13. He continued his treatment till December 2013. He has not yet cured fully and treatment is still going on. Nothing has been elicited during the cross-examination of PW to raise any doubt regarding the veracity of the above claims on the issue. The contesting opposite party also have not adduced any contrary evidence on the issue. Exhibit 1 Accident Information Report form number 54 supports his claim that the aforesaid accident involving the aforesaid offending vehicle motorcycle number so and so took place in the aforesaid place of occurrence at the aforesaid time of the aforesaid date, causing injury to claimant Nirmal Taluka, and that Beltala PS case registered a case by PS case number so and so under section so and so against the rider of the aforesaid motorcycle regarding the accident. Insurance company examined one Madhuram Kolita SDW. He has stated that their insurance investigator Mundin Sharma investigated the case and collected the copy of FIR. Exhibit A is the FIR number 320 dated 9/7/10. Exhibit B is the certified copy of the Ejahat dated 9/7/10. As per these exhibits, no vehicle was involved. An unknown vehicle knocked and their vehicle was not involved. During cross-examination, he admitted that the bike in which the claimant was proceeding an unknown vehicle knocked him. So this evidence was adduced by the insurance company also. And we are in our appeal, we are relying on this because the FIR itself is the genesis of any claim lordship is based on the FIR or the GD entry, and the FIR was filed by them only, which showed that an unknown vehicle had caused the accident. In view of the above evidence on record as well as documents submitted by him, it is found and held that the aforesaid offending vehicle, motorcycle bearing number 1, so and so, was solely responsible for the accident. This is so contrary, Lordship. On the above paragraph, it is mentioned that it was unknown vehicle, and here the court comes to the finding that based on that evidence, this vehicle was involved in the accident. It is totally contradictory to the defense evidence adduced. In view of above oral and documentary evidence on record, it is found and held that issue number 1 is decided in the affirmative. Issue number 2. In view of the decision arrived at in respect of issue number 1, it is found and held that the claimant is certainly entitled to receive compensation in this case. In determining the quantum of compensation the claimant is entitled to receive, let us first find out the nature and extent of injury suffered by him in the accident, the nature and extent of the treatment received by him for such injury, and the extent of expenditure incurred by him for such treatment. Regarding the nature and the extent of injury sustained by the claimant in the accident, and the nature and the extent of treatment received by him from such injury, according to claimant PW1, he sustained multiple comminuted depression, fracture injury on his right frontal bone, multiple facial and nasal bone fractures, contusions in left frontal and temporal region, and multiple injuries all over the body. After the accident, he was immediately taken to Agile Hospital, but due to his serious condition, he was referred to GNRC Hospital and took treatment there from 6/7/10 to 4/8/10 as an indoor patient. Thereafter, he took treatment from 11/3/11 to 9/8/11 and then 21/9/12 and 14/12/12. He also took treatment under Dr. Virendra P. Singh, senior neurosurgeon of Indraprasth Hospital, New Delhi. On Lordship, this part, we are also challenging that his treatment, Lordship, in 6/7/2010 to 4/8/2010, we do not have any objection to that. But the later treatment is related to eye, Lordship. So that we are objecting to. Who came to Gauhati, he has not yet cured and his treatment is still going on. The claimant has proved Exhibit 2 as discharge summary and advice of GNRC. Exhibit 3 is consent letter for ventilation in GNRC. Exhibit 4, 1 to 20 as prescription. Exhibit 5 is diet prescription. Exhibit 6 as the money testing advice and prescription of GNRC. Exhibit 7, 1 and 2 as memory assessment report. Exhibit 8 to Exhibit 10 as prescription. Exhibit 11 as prescription of Mechi Eye Hospital, Nepal. Lordship, these documents we are objecting to. Exhibit 11, Exhibit 12 as prescription of Dr. Virendra Preesing. Exhibit 13 to 14 as prescriptions. Exhibit 15 as photographs of the injured. Exhibit 16 as salary cum employment certificate issued by Satya Ranjan Haloi. Exhibit 2 discharge certificate issued by GNRC Hospital shows that he took treatment there as an indoor patient, was admitted there on 6/7/10 and was discharged on 5/8/10. He was diagnosed as suffering from severe head injury. It has been mentioned that he was initially treated at Agile Hospital and then he was brought to GNRC. CT scan brain reveals there is significant evacuation of the right frontal epidural hematoma. Left front temporal contusion also shows progressive resolution. Overall mass effect has decreased. MDCT polytrauma reveals there was epidural hematoma in right frontal region, size 6 into 2.4 centimeter. Contusions in left frontal and temporal region. Multiple comminuted depression, fractures of right frontal bone involving the orbital roof. Linear fracture of the left frontal bone involving the orbital roof. Fractures of anterior and posterior wall of right maxillar sinus and fracture of right lateral orbital wall. Collection is in maxillary, ethmoid and sphenoid sinuses. He was advised for rest for 6 weeks. Exhibit 3 is the consent letter for ventilation in GNRC. 7, 1 and 2 are memory assessment report which reveal that the PGT finding shows absence of disturbance in his perceptual and gestal functions. The above finding shows poor remote memory, attention and concentration and immediate recall. In view of above discussion, it is found and held that the claimant sustained grievous head injury in the accident. Regarding the extent of expenditure incurred by the claimant for his treatment, he, PW1, stated that he'd spent more than 10 lakhs only for his treatment. He has submitted Exhibit 17, 1 to 74 as cash memos for purchasing medicine in support of his claim. On perusal of the aforesaid document, it is found he spent about rupees 2,79,251, say 2,79,500 for his treatment, and he is entitled to get this amount as compensation. Lordship, the entire amount is given, but there are no corresponding prescriptions, Lordship. According to claimant, he was serving as site supervisor under Satya Ranjan Haloi to supervise his construction work. Exhibit 16 is the salary cum employment certificate issued by Satya Ranjan Haloi. Shows that claimant Nirmal Talukdar was serving as site supervisor under him for his construction work since 13 months back till his date of accident, and his monthly salary was rupees 6,000. Lordship, this author of this Exhibit 16 never adduced evidence in the case to prove the employment and income of the injured, Lordship. Due to the accident and injury, he was not fully recovered from his injuries, but he has not filed any documentary evidence regarding permanent disability. He has filed Exhibit 6, 8, 10, 13, 14, 1, 2 as prescription issued by GNRC, shows that he continued his treatment from 6, 7, 10 to 31, 12, 13. Exhibit 16 salary certificate issued by Satya Ranjan Haloi, which shows that claimant was working as site supervisor under him for his construction work since 13 months back till his date of accident, and his monthly salary was rupees 6,000. But the person who issued the certificate has not come to prove the same. So his profession and income is not proved. Hence his income is assumed to be rupees 5,000 per month, and he is entitled to get compensation during the period of his treatment, that is for 1 year. He is entitled to get 60,000, 5,000 into 12 for loss of income. Considering the nature and extent of injuries sustained by him in the accident, it is held that he is not also entitled to receive an amount for pain and suffering, loss of amenities of life, incidental expenses toward hospitalization, transportation, special food, nursing, etc. Thus, the total amount of compensation the claimant is entitled to receive is assessed as under. Lordship, I'll just pause here for a moment. The paragraph before that, Lordship, the court comes to a finding that he was taking treatment for 1 year, Lordship. But then, Lordship, the documents that were accepted by the court was of 2013 also, whereas the accident took place in 2010. Because the eye treatment was taken in 2011, 2012, or also 2013, Lordship.
Yes.
Then medical expenses, this is the, then the total compensation granted is, Lordship, 6,29,000. And as per the claim, the offending vehicle was insured with OP number 3 insurance company at the relevant time. Exhibit 1 form number 54 supports that fact. Hence, it is held that OP number 3 insurance company is liable to pay the aforesaid amount to the claimant as compensation in this case, Lordship. So 6% with 6% interest. So our contention is that, Lordship, when we adduced evidence, we proved the FIR, an unknown vehicle was involved in the accident, Lordship. The insurance company cannot be made liable to pay compensation when this vehicle was not even, because the case was filed under section 166, rash and negligence. The first point of rash and negligence is that there should be a rash and negligence, then only they can claim compensation. But here that was not so, Lordship. I would like to rely on this judgment, Lordship, New India Assurance versus Bismillah by, Lordship, wherein the apex court held, since what happened in this case, Lordship, there were 2 vehicles involved. Okay, the photos. Lordship, what happened in this case was that 2 vehicles were involved, a jeep and a truck. Since the other vehicle did not have a insurance policy, the tribunal, the High Court fastened the liability on the vehicle but where there was no rash and negligence, Lordship, on that vehicle. So apex court held that that cannot be done, Lordship. Paragraph 6, Lordship. 6, 7, and 8, Lordship. No, 6 and 7. The question as to whether the driver of the jeep or the truck and or both of them were responsible for negligence in driving their respective vehicle which led to the said accident is essentially a question of fact. While reversing the said finding of fact so as to fasten the liability on the insurance company, the High Court was required to assign sufficient and cogent reason. No such finding to the effect that both drivers as also the jeep contributed to the negligence having been recorded by the High Court, the question of fastening the joint liability by the insurance company did not arise because the tribunal had given the said that the truck was not liable, but High Court changed it. Only because the truck was not insured, the same by itself did not mean that the appellant insurance company can be held liable to reimburse the claim to the claimants. Wherefore, liability has been incurred by the owner and driver of the truck, and therefore no liability has been incurred by the driver and owner of the jeep is concerned. Lordship, this. And Lordship, my humble submission that this was a hit and run case. The hit and run case are the government itself pays the compensation, Lordship. They can apply for before the government to before the DC of the concerned district, Lordship, and they can get the compensation from there. When the other vehicle was, they could not find the other vehicle. There is a provision for hit and run cases, Lordship.
What provision?
That I will find out and then, Lordship. So my basic, let him complete, then I'll give that hit and run scheme. Lordship. Huh? इत्यादि दिलू इत्यादि जजमेंट क्यों करूँ in the meantime injured died injured died lordship the legal as per yeah. And that is what I submitted on in the other case lordship the case they have filed lordship whether it will lordship will look into the fact whether it is maintainable in because the injured has died so can an appeal be maintained lordship so reply but in the meantime he can go.
Lordship, so far,
Yes.
whether my appeal is maintainable or not, and whether after the death of the injured, whether I can challenge this award pass against them, whether my right survives or not. On that point, first I will submit it. Then I will come on the negligence point and other points.
Okay.
Now, your lordship, so far, the question is whether the claim case be abated on the death of the claimant, where the death is not caused in the consequence of the accident. And here it is, frankly speaking, it's not a case that I died due to accident. The death occurred afterward, after he filed the appeal, he died. So there is no relation between death and accident. But the injury was there. So whether in this case, whether I can contest the claim which was awarded to me by the trial court, whether I can defend that claim. First, that will come. Whether my right to defend the claim, because what was the award passed? It became a state to me. After his death, it became a state to me, and I can very much, I can argue, your lordship, I can defend that award pass. On that, I will submit two cases, your lordship. Your lordship, in the award in favor of the claimant, appeal by the person directed to pay compensation, right of LR would not abate, and LR can be substituted as the award in favor of the in favor of the deceased part of state left behind the deceased. On this, your lordship, I cite one Supreme Court case, your lordship. 1986, lordship, I am giving this citation, your lordship, kindly see. Lordship, lordship, it is 1986, 1 SCC, page 118. I am referring, your lordship. Lordship, go to page 10, your lordship, my note.
Yes.
Your lordship, we can directly come to head note lower part. Before it is elaborated in para 11. I am going to para 11 directly, your lordship. The position, therefore, is that had the appellant died during the pendency of the suit would have abated. Had he died during the pendency of the appeal, because there are three situations, your lordship. A person got injured before filing a claim. That is one situation. Second situation, during pendency of the claim petition. And third, during the pendency of appeal. There are three situations are mentioned by the Honorable Supreme Court. The position, therefore, is that the appellant died during the pendency of his suit, the suit would have abated. Had he died during the pendency of the appeal filed by him in the district court, the appeal would have equally abated because his suit had been dismissed by the trial court. Had he, however, died during the pendency of the second appeal filed by the respondent in the High Court, the appeal would not have awaited because he had succeeded in the first appeal and his suit has been decreed. As however, the High Court allowed the second appeal and dismissed the suit, the present appeal by special leave must await because what the appellant was seeking in the appeal was to enforce his right to sue for damages for defamation. This right did not survive his death, and accordingly the appeal awaited automatically on his death, and his legal representative acquired no right in law to be brought on record in his place. Lordship, here is what they say, it was a defamation case. The petitioner before the appeal,
This goes against you, 11.
yes, it died because he died before passing any award. Because
Okay.
his appeal was the first appellate court dismissed, and then he preferred again an appeal. That time, your lordship, whether he dies, whether when he dies, there is no award in his favor.
Okay.
Now, your lordship, and regarding your lordship, please come to the head note lower part, your lordship. The position, however, is different, lordship, page number 10A.
Yes.
The position, however, is different, where a suit for defamation has resulted in a decree in favor of the plaintiff because in such a case, the cause of action has merged in the degree and the decretal debt form part of his state, and the appeal from the degree by the defendant becomes a question of benefit or detriment to the estate of the plaintiff respondent, which his legal representative is entitled to uphold and defend, and is therefore entitled to be substituted in place of the deceased. So, there are two situations, your lordship. Once when there is no award, suppose in trial court there is no award. In that case, that paragraph 11, lordship. But if there is, lordship, an award, and the aggrieved party, here insurance company, they have come in appeal. So that award which has passed against me, passed in my favor, it become my state, and I can defend. Am I clear, lordship?
Yes.
Your lordship, this is then another judgment, your lordship. Your lordship, this is 2009 4 GLR 64, your lordship. This is para 8. This is 2009 4 Gauhati Law Report, page 64. This is Parvartak Ghosh versus Gautam Das. Lordship, here lordship may kindly come to para 8, lordship. What logically follows from the observation made above in Melpurtho Sankoni Supra is that when injured sues or makes an application to claim tribunal seeking compensation, the right to sue does not survive if during the lifetime of the injured, the injured proceeding do not culminate into the award in his favor. If the claim for compensation result into an award in favor of the injured, and an appeal is preferred by the person who is directed to pay the compensation awarded to such an injured, the appeal against such award would not await, and his legal representative of such an injured can be substituted for the award rendered in favor of such injured claimant, forms part of the estate left behind by the deceased. So, lordship, situation here is different, lordship, because an award was already passed in my favor in the trial court. And this legal errors, if I die during the pendency of the appeal, which is prepared by the aggrieved party, the insurance company, I can very much come for defending this award. Am I clear, lordship?
Clear.
And there is one more judgment on that I will come later on, your lordship. So this is first. Then one point which is first point raised by my learned friend is regarding negligence. That I was hit by, it is a hit and run case.
Yes.
As per them, it is a hit and run case, which is not so, Your Lordship. Here, Lordship, just before coming to the text, Your Lordship, I was a pillion rider. My rider, in which the scooter I was going, he overtook one vehicle. This is in the pleading as well as evidence and the
And put brakes,
and after overtaking, he puts
brakes.
all of a sudden, and from behind, the unknown vehicle hit and run. Now my point is this, Your Lordship, that so far he is concerned by applying brake just after overtaking, he committed some negligence. Then, Your Lordship, of course, the vehicle who hit and ran, that was equally responsible. But now, whether my claim will I can lose claim against this insurance company or against that runaway vehicle. It is a case of composite negligence. In case of composite negligence, Your Lordship, I have option. I can go against both or either or both of the vehicle. That point I will submit after Your Lordship.
Yes.
That's it.
Now we will continue.
Acha, Lordship. So, Your Lordship, they are relying because, Your Lordship, there is no eyewitness. Only I was the eyewitness because I was pillion rider. The person who filed the FIR, Exhibit A, he is not eyewitness. And who is person exhibit who filed the FIR, Lordship?
Who filed the affair?
He is the father of the owner of the vehicle. And what his FIR says, Your Lordship? He says that a vehicle hit and run away. This is simple FIR there. And whether that person saw it, because he did not come to the witness box. His father of the owner. And owner is not supposed to speak because owner was who? Owner was he was not supposed to write anything in the FIR against his son. He was not supposed to write anything against his son, so as to involve in some criminal case of rash and negligent driving. You also may kindly see his FIR. That is Exhibit A, also. It is simple. That one vehicle, it is Exhibit A is there, you also. Father filed an FIR because what for he filed? His purpose was only to get own damage for the because the vehicle was in his father's name. He filed the FIR. He filed not FIR for me. He filed the FIR for getting compensation for his own damages. He is Ranjit Talukdar. His OP number He Ranjit Talukdar, he himself filed the FIR. He is the owner of the vehicle. And he was not driving. His son was driving.
Okay.
Your Lordship got the FIR, no? Exhibit A, Lordship. Your Lordship, this is it is simple, Your Lordship. So far, what type copy I am having, I am reading, Your Lordship. If I am correct, Your Lordship may kindly see the.
You flagged the affair.
Yes. So, Lordship, my humble submission is this. The insurance company witness, he wholly relied upon Exhibit A. Exhibit A, he is not the eyewitness. Insurance company witness, he was not the eyewitness. Person who filed the FIR, he is owner himself, whose son was driving, and just a minute.
Oh, I got your point. Let her find the FIR. You continue your submission.
Yes, sir. So, Lordship, so far exhibit A is concerned, it was filed by the owner, father of the rider of the motorcycle, which mentioned that the accident took place due to unknown vehicle. He was not supposed to say that because of the negligence of his son, the accident took place. So my case is this: when overtaking the vehicle, this is not disputed. These things not disputed at all in the cross examination. And what statement is there in my claim petition? Exactly same statement is in my this evidence, Your Lordship. That statement I am reading, Your Lordship. Kindly see, Your Lordship. It is, Your Lordship, near SBI Belkala branch. Near, Your Lordship, it is my page number 6, Your Lordship. I have quoted that. Near SBI Belkala branch on Baltala Basista Road, just after overtaking one unknown motorcycle. Just after overtaking an unknown motorcycle, Sri Parth Pritim Talukdar, rider of the motorcycle, applied brake, and the unknown motorcycle knocked down our motorcycle from backside. And this statement, Your Lordship, is not challenged in the cross examination by anyone. And on this finding, this statement, Your Lordship, the court held
Okay. Yes.
so on this statement it was. This is in my claim petition also, in my PW1. And PW1 is none, but he himself, the opinion writer, the eyewitness. So far negligence is concerned, and their report was based on one investigator. He is one, Your Lordship, Munin Sharma. Their investigator, Your Lordship. He must have gone there and inquired, I suppose, collected these papers. And he was also not examined by the insurance company.
Okay.
And in this regard, Your Lordship, I like to submit first, because, Your Lordship, so far this negligence is concerned, the authority which in all Gauhati cases also, other cases also, this one is relied. Here 1980 Supreme Court 1354, Lordship will find as page 26, Lordship. It is you. NKB Brothers versus Kurmulan. Our refer for also 95. Lordship may kindly come to page 26, Lordship, of citation which I have given. Held, Lordship. I'm reading just of the head note, Your Lordship.
Yes.
Lordship, may it is in the head note and also in paragraph 3.
Read para 3.
Para 3. Road accident are one of the top killers in our country, especially when truck and bus drivers operate nocturnally. This proverbial recklessness often persuades the courts, as has been observed by us earlier in other cases, to draw an initial presumption in several cases based on the doctrine of res ipsa licita. Accident tribunal must take special care to see that innocent victims do not suffer, and drivers and owner do not escape liability merely because of some doubt here or some obscurity there. Save in plain cases, culpability must be inferred from the circumstances where it is fairly reasonable. The court should not succumb to niceties, technicalities, and maybe. So let's say this is the first case which I found 1980 Supreme Court. Let's say our 1995 Supreme Court Saraswati Devnath, that is also based on this case. Let's say that is there may be, because let's say it is the law is made for the victims of the accident, and when the case is very clear that after overtaking he stopped, there is no cross examination, then there is no option but to held that he was negligent. Of course, that other vehicle which ran away, it may be equally negligent. But your lordship, in that matter, I will come to the composite part of the negligence, your lordship. Then your lordship, another case, your lordship may kindly see at page 23, lordship. Page 23, lordship.
Yes.
Lordship, it is your lordship 1995 2 GRT 117. We are referring these cases in almost all the cases. Para 6, your lordship, Union of India versus Mrs. Saraswati Devnath. Para 6, your lordship. The law is settled that in a claim under Motor Vehicle Act, the evidence should not be scrutinized in the manner as done in the civil suit or a criminal case. In a civil case, the rule is preponderance of probability, and in a criminal case, the rule is proof beyond reasonable doubt. It is not necessary to consider these niceties in a matter of accident claim case, in as much as it is summary inquiry. If there is some evidence to arrive at the finding, that itself is sufficient. No nicety, doubt, or suspicion should weigh with the tribunal in motor accident claim cases. And here, lordship, that the judgment I referred 1980 was delayed. Then, your lordship, the third case, 2009 13 SCC 530. This is Bimla Devi versus Himachal Road Transport Corporation. Lordship, your lordship, may kindly see page 28 of my note, your lordship. 28A, lordship. After 28, 28A is there. I am coming to directly to paragraph 15 at page 28, your lordship. In a situation, your lordship, which is regarding taking holistic view of the matter. In a situation of this nature, the tribunal has rightly taken a holistic view of the matter. It was necessary to be borne in mind that strict proof of an accident caused by a particular bus in a particular manner may not be possible to be done by the claimant. The claimants were merely to establish their case on the touchstone of preponderance or probability. The standard of proof beyond reasonable doubt could not have been applied. For the said purpose, the High Court should have taken into consideration the respective stories set forth by both the parties. Then I will submit because my learned friend says that even if your lordship assume that yes, there was negligence, your lordship will say that two vehicles was involved, so other vehicle was equally responsible, so it will affect my award. Now, your lordship, in this regard, there is two types of cases. One is contributing negligence, one is composite negligence. Lordship knows that contributing negligence is one where the claimant or the deceased, he contributed to the accident. Suppose he was going by the vehicle and there was accident takes place. He was also responsible. In that case, it is contributing negligence. But an accident between two vehicles where a claimant or a third party is not responsible, that is called, lordship knows, composite negligence. In case of composite negligence, in lordship, Honorable Supreme Court as well as our own High Court says the claimant has option. He can either proceed against both the vehicle or any one of the vehicle. And in my case also it happened, Your Lordship. So first I am coming to 2008 3 SCC page 748. It is at page 32, Lordship, which I have given. Lordship, may kindly come to para 6 directly, Your Lordship. Composite negligence, Lordship, got it?
Yes.
Composite negligence refers to the negligence on the part of two or more persons, where a person is injured as a result of negligence on the part of two or more wrongdoers. It is said that the person was injured on account of the composite negligence of those wrongdoers. In such a case, each wrongdoer is jointly and severally liable to the injured for payment of the entire damage, and the injured person has the choice of proceeding against all or any of them. In such a case, the injured need not establish the extent of responsibility of each wrongdoer separately, nor it is necessary for the court to determine the extent of liability of each wrongdoer separately. In this regard, Your Lord, in many cases, our Gauhati High Court also, when a rail or road accident takes place,
Okay.
in that case, on the Supreme Court, Gauhati High Court also held that yes, it is because composite negligence, I can file a MSCT claim also and get the compensation. The next case, Your Lordship, it is our own High Court, Your Lordship, as page 36.
No, when Supreme Court, you are citing Supreme Court, no necessity of citing our own High Court.
Because our Gauhati High Court followed this and because not necessary. Your
We
Lordship.
don't have any option
Yeah.
but to follow.
Yes.
If Supreme Court has said,
Yes, Lord. So this will do, Your Lordship.
yes.
So far negligence is concerned, I think I am clear to Your Lordship, but they have said their case. What is my case? I have submitted, and I suppose, Your Lordship, I think I have able to satisfy.
What is your response to the submissions made by learned counsel for the appellant that your treatment expenses incurred in the treatment was of treatment of eye injury?
Your Lordship, I will come to the first document which are in JNRC. I will show that it was including I and everything. It was not one. I'm going exhibit by exhibit what happened. The exhibit which belong to JNRC. I will show Your Lordship. I have noted all this.
And whether the cash memos have corresponding prescriptions?
Yes, Lordship, a claimant. These are GNRC bills, suppose, and whether the bill which I have submitted, whether they relate to my treatment or my injury or not, because a person who meet with an accident, Your Lordship, because in our system, Your Lordship, the keeping of memos, keeping of papers, we are not that efficient. Nowadays, of course, there is digital and all this, we can keep it. But previously, Lordship, it is not possible, Your Lordship. A person, when he got injured in 1 month, he is in GNRC, he will take care of himself or he will take care of cash memo and prescription. And whatever available with him, that is not about 100 documents he has filed.
Okay.
I'm coming to those memos, Your Lordship. If my learned friend case, so this is not related to the treatment which I have undergone originally, then matter would have been different, Your Lordship. Sure. Just a minute, Lordship. Lordship, may kindly see what is my injury, Your Lordship. First, Lordship, may see exhibit 2. Whatever the court has recorded, These are the injuries which are in Exhibit 2, Exhibit 3, Exhibit 4. So far, Lordship, I have just, Lordship may note, Lordship. So far, multiple committed depressed fracture of right front. It is not that only my eye was injured. It is my frontal bone on the head. That is Exhibit 2 is there. Lordship may come to page 3, Lordship. Lordship, multiple committed, this is Exhibit 2.
Yes.
Multiple committed depressed fracture of right frontal bone on the head. It is there, Lordship. Yes, Your Lordship.
Yes.
It is there. Now, another multiple facial and nasal bone fracture. This is also there. Page number, Exhibit 2, page number 3, Your Lordship.
Yes.
Then, contusion in left frontal and temporal region. This is Exhibit 2, page 4. Because what the court noted the injury, I have noted on which page it is there. Multiple injury all over the body, it is Exhibit 2, page 2.
Yes.
Then your memory problem, Exhibit 7 and Exhibit 7172. Memory problem. Lordship, 7172.
Okay. Yes.
Then right eye also damage. Your Lordship may kindly see Exhibit 11.
Exhibit 11.
Exhibit 11. This is regarding my injury. So far, hospitalization is concerned, Your Lordship, because it was 2 times. First, Your Lordship may kindly see Exhibit 1 and 2, 6, 7, 10. First, I went to another hospital. Then I was referred to GNRC. That is Exhibit 2 from 6, 7, 10 to 5, 8, 10. Almost 30 days. 1 month. Exhibit 2. It is on the top. Then again, I had to take treatment between 6, 7, 10 to 31, 12, 13, Your Lordship. For more than 3 years, treatment taken in GNRC, Your Lordship may kindly see, not in other hospital. Exhibit 2 to 10, Exhibit 13, 14, 14, 1, 14, 2, 15. And I was kept under ventilation, that is Exhibit 3. And I was operated on 6th, 7, 10. It is also, Your Lordship, it is in the fracture evolution. It is there in the, it is Exhibit 2 itself, Exhibit 2. Now, Your Lordship, I have gave evidence of myself, the disease now. And I have exhibited altogether 17 documents, out of which, Your Lordship, 17, 1 to 74 are the case memos. Just a minute, Lordship. Your Lordship, Exhibit 2 to 17, because in Exhibit 13, there are 14 documents. In Exhibit 17, there are 74 documents. Exhibit 1 to 7, 2 to 17 are regarding my injury, treatment, hospitalization, everything.
Yes.
So, Lordship, it is not a case that some false case has been filed. Here, Your Lordship, person was really injured and his injury was duly recorded in the order sheet also, judgment also. And these are the documents. Based on these documents, court came to the finding that I spent so much. And exactly what happened, Your Lordship, this 270, I filed the vouchers. I filed the vouchers. Apart from this, your lordship, when a person for 1 month, he remains in hospital and for 3 years he is under treatment, because my prescription there and all these things are for 3 years, not 1 year. Then, your lordship, whether nursing from home or nursing from outside, it is not free, your lordship. If somebody attends me, it may be my housemaker, my children, your lordship, they have to forego their work. So it is not free. So some amount on this count, your lordship, that for during my treatment, somebody attended me, my for nutrition, my these foods and all these things, your lordship, these are not reflected here.
Okay.
Or nowadays we make payment, suppose by G this code and all. Previously, your lordship, all payment used to be made in cash. Whether one can account how he spent the amount, because 274 it has come because of the vouchers. But your lordship, this is the only expenses he made for 3 years. Suppose he was going to the hospital, GNRC, from his place. There is nothing to show that what expenses he incurred for taxi and for going to the hospital. This is not there on record. So, you know, this amicity cases, so they are concerned, you know, it is rightly said, there is some guesswork, some amount of sympathy that is required here also. Some guesswork, some amount of sympathy in the case of an injured. Here, an injured has come who has suffered for more than 3 years. And of course, he died, not because of the accident, he is no more.
Okay.
Now, your lordship. So, I humbly submit, your lordship. So far, this award is concerned, your lordship, I can, it is being the state of the disease, your lordship, in view of the Supreme Court judgment, these 2 judgments which I have cited, I can very much defend it to the hilt. This is my submission about their appeal. Regarding my further claim, your lordship, if your lordship permit, then I will submit, your lordship.
Yes, on what basis you are seeking enhancement?
Because in my claim, I asked for the enhancement. Now, what enhancement I can claim? There are 2 types of damages. So far, your lordship, special damages are concerned, I can claim. Even after the death of the person, his legal heirs, so far the special damage like medical expenses, loss of income, these things can be claimed. And I have citation of this Honorable Court also on this one. May I submit, your lordship?
Yes.
Your lordship, by the way, in this case, I was there. Your lordship, I have second. Anyway, I will give the lordship. I may simply appeal 165 of 2010. I am giving this one, your lordship. This is, your lordship's Sthiti Sutradhar Bhache, New India Insurance Company, your lordship. In this case, your lordship, I am reading slowly 3 paragraphs, your lordship.
Yes.
To bring home the point that whether this legal heirs, they can claim so far the special damage are concerned. And what is it, this special damages, your lordship, very closely. Now, your lordship, I am reading the relevant paragraphs. Lordship, here the same point was raised. Paragraph 3, your lordship. Paragraph 2. The question which has arisen in this appeal is as to whether the legal heirs of the deceased claimant who sustained injury on vehicular accident and died subsequently unconnected with the injury sustained in the road accident are entitled to continue the claim for compensation. This is the point raised in paragraph 2. Then, your lordship, the landed counsel so and so for the landed counsel for the appellant has contended that when the injured dies, the question of grant of general damages does not arise. But the legal representative is entitled for special damages such as medical expenses, actual loss of income, miscellaneous expenses, like this. I can always claim. Then also I'm coming to the finding. That is in paragraph 19, Lordship.
You mark the paragraph.
I will write here, Lordship, on the top. And your Lordship, entire judgment is on this point. When the person died, what compensation given?
It was held ultimately.
Lordship?
What was held?
Ah, yes, Lord. Para 19, 2 and 5. Lordship, I'm reading paragraph 9. That in that view of the matter, the person appeal is the present appeal is maintainable only to the extent of pecuniary loss caused to the state of the deceased, Srimati Sthiti Sutrata. So now, these damages were discussed and what was allowed, what was not allowed, that is there. I'm giving this judgment. Here, your Lordship, so far, because income is special damages.
Yes.
So far, my appeal is concerned, your Lordship. I mainly, your Lordship, on income, Lordship. Here, Lordship, this person, this was a claim under 166. So far, 163 is goes. The loss of income is given most probably for 1 year, I suppose, your Lordship. But it is a claim under 166. And this honorable court, your Lordship, the London trial court, your Lordship, granted, adjust my income is 5,000 rupees and granted 1 year loss of income. If your Lordship will go through the documents and my submission, your Lordship will see that.
No, is there any evidence to suggest that you were unable to perform your duties for so much period of time?
It is in my evidence. It is in my evidence because only I gave evidence. So far, my evidence, there is nothing. Of course, they may say that I am saying high and all, but court accepted my income as 5,000 rupees.
No. My query is, did you adduce any evidence to, in your oral testimony only, whether you stated that due to injury sustained by accident, you were unable to do your normal work for 3 years?
Yes, Lord, rightly, your Lordship has put that question. I'm coming to the evidence part. Lordship, this claim was filed in 2011. The claim was filed on 8th day of July 2000, Lordship, 8th day of July 2014.
Oh, this is evidence.
No, this is evidence.
Evidence.
No, evidence was there. Claim was filed in 2011. Claim was 11.
No answer to my query.
Yes, I'm coming. That I'm coming to his evidence. Evidence regarding evidence in Lordship.
Yes.
Paragraph 9, I am reading slowly, your Lordship. That even after spending of money in treatment, I have not recovered even today I feel pain in my head, my right eye damage, and as a result, I am unable to see through my right eye, and my memory has been lost to some extent. This was when the 14 he gave the evidence. He's saying on that day, this evidence was recorded on 8th day
No,
of
my
July.
query was different. My query was, is there any direct evidence where you stated that due to the injury sustained by you, you were not able to earn which you were earning earlier for this much period?
Lordship, because there are only two documents. One is because I was working under someone that document I have approved, but of course the author of the document I have not got. Because I was working on contractor.
No, that is not my query. Accepting that you were earning rupees 5,000 per month, 5,000 or 6,000?
I was 6,000 I said, but court held.
Court
5,000.
held it 5,000.
Yes, Lordship.
My query is that court gave you compensation against loss of earning for a period of 1 year. Is there any evidence to contrary that you were unable to earn for a longer period than 1 year? Is there any direct evidence? What you have shown just now only suggests that he was having pain in eye and he was still suffering. But whether that
He was
suffering,
disabled,
but
partially
whether that
disabled
suffering made him unable to perform his work so that his earning is affected. Okay, I'll go through the. Anything else, Mr. Jain?
Lordship, I just, apart from what I have stated in claim petition in 2011, 2014, that paragraph 9 is there, that which shows that disability, because when there is some disability, and the sort of disability which I have mentioned, Your Lordship, there must be loss of income for that period. It may be, what I am claim, it may be maybe some less or it may be more, but there was some loss because after sustaining so many injuries and all, it is not, it may not be that he has not sustained his working was not affected due to that.
Okay. You are pleading for assuming, the court should assume that there is a loss of earning.
Lordship, so far MSCT courts are concerned, Lordship, whether it is appeal, Lordship, some amount of guesswork is to be done.
Okay. Yes. What is the reply?
And one more, Lordship, so far negligence is concerned, I have stated that submitted that so far that particular paragraph regarding negligence is concerned, how accident took place.
Yes.
Lordship, there is no cross-examination. And there is cases that
Yes,
if
that
there
you
is
have
no
sub-
cross-examination. In case of no cross-examination, the version given by the witness should be accepted.
Okay.
Lordship, what my senior is saying that there was a treatment for 3 years. That is not so, Lordship. JNRC treatment ended in 2010. Thereafter, he took a different treatment in 2012 and 2013. Eye treatment, Lordship, is of November 2012 after 2 years, 4 months of the accident, Lordship. And all the expenditure documents are related to eye treatment. JNRC treatment, only small amount is there. He went to Nepal and that is in November 2012, after 2 years, 4 months of the accident. They are not related to the accident. And Lordship, about the rational negligence, about our exhibit, they have not objected to the FIR that we exhibited as Exhibit A. They have not objected to that. It was accepted by them. About rational negligence, that we are saying that unknown vehicle lordship. And about unknown vehicle lordship, when there is tension, we forget about the sections. Lordship, section 161 of the MB Act, lordship. Special provisions as to compensation in case of hit and run motor accident.
Okay.
I'll read it, lordship, or
Yes, you may read.
notwithstanding anything contained in any other law for the time being in force, or any instrument having the force of law, the central government should provide for paying in accordance with the provision of this act and the scheme made under subsection 3, compensation in respect of death of or grievous injuries to persons resulting from hit and run motor accident. Subject to the provisions of this act and the scheme made under subsection 3, there shall be paid as compensation in respect of death of any person resulting from hit and run motor accident a fixed sum of rupees 2 lakh or such higher amount as may be prescribed by the central government. B. In respect of grievous hurt to any person resulting from a hit and run motor accident, a fixed sum of rupees 50,000 rupees or such higher amount as may be prescribed by the central government. Lordship.
Okay.
So here for hit and run, and I do not know the latest notification of our state budget, how they are going to pay, but this is the provision. So Lordship, the FIR was not objected to, it was exhibited by us. Lordship, much emphasis was made on the EA, and in the judgment also, many technical words are mentioned by the tribunal, Lordship. But no doctor adduced evidence. Now my senior is saying that there was disability. He has gone to the extent in his claim, in his own appeal, to go to suggest that there was disability. But there is no disability proof. Rajkumar Ajay Kumar is very clear on that, Lordship. There was no disability certificate, nothing. Either of the brain or ear. And if he was disabled by mental disabled, he could not have adduced evidence, Lordship. That itself.
No, the tribunal did not say anything about disability.
Yeah, no, my submission. I'm replying to his submission. Now he's submitting that Lordship will make a guesswork that there was a disability. That cannot be, Lordship. Rajkumar Ajay Kumar is very clear on that, Lordship. And no doctor reduced evidence, Lordship. And about the unknown ration negligence, Lordship, unknown vehicle is mentioned by the claimant themselves. They have mentioned that from the backside the vehicle, yeah, from the backside the vehicle had hit the motorcycle, Lordship.
Okay.
And my senior is also accepting that there might be some contribution, but there is no some contribution, Lordship. The accident took place due to that unknown vehicle only. And Lordship, pecuniary and non-pecuniary damages, they are asking, Lordship, about pain and suffering and all that. He has already died, so there cannot be any more compensation to the deceased, Lordship, on those grounds. Already the medical expenditure and everything is mentioned, so there cannot be increase in that. In fact, there will be decrease because all the prescriptions are not related to his accident in 2010, Lordship. The GMC eye treatment expenditures are not to be included. That was taken after 2 years, 4 months. Then, Lordship, again, this is submitted that loss of income. For what already we are challenging that 1 year loss of income, Lordship, because there is nothing to show that there was loss of. He was in GNRC for 1 month only. Loss of income was for that 1 month. But the tribunal has given for 1 year, 60,000 rupees, Lordship.
The claimant died during the pendency of the appeal.
Yes.
Pendency of the appeal.
But he did not die because of the accident, not.
That is true.
Heard. Mr. Heard Miss Adi Majumdar, the learned counsel for the appellant in MAC appeal number 336/2017 as well as respondent number 3 as well as respondent number 3 in MAC appeal number 15/2017. Also heard Mr. B.K. Jain, the learned counsel for the respondent/claimant in MAC appeal number 336/2017 as
15/7.
336
6 is my file by me. 15/7.
is respondent 336 of 2017 as well as appellant in MAC appeal number 15/2017. Take your seat for 10 minutes. By this common judgment, this court proposes to dispose of two connected appeal arising out of the same judgment. Stop. The MAC appeal number 336/2017 has been filed by the appellant, namely National Insurance Company Limited, impugning the judgment and award dated 7/9/2016, passed by the Motor Accident Claims Tribunal number 1, Kamrup, in MAC case number 804/2011. In the said appeal, the appellant insurance company has impugned the judgment on the aforesaid judgment on the ground that the liability to pay compensation by the present appellant was wrongly attributed by the claims tribunal on the present appellant when the accident involved in this case is a clear case of accident resulted due to hit and run by an unknown vehicle. The appellant has also questioned the quantum of compensation paid by the tribunal to the claimant. On the other hand, MAC appeal number 15/2017 has been filed by the claimant late Nirmal Talukdar, seeking enhancement of the quantum of compensation paid by the tribunal. Stop. It is pertinent to mention herein that during the pendency of both these appeals, the claimant Nirmal Talukdar had expired and his legal heirs were substituted in his place. The next para. The facts relevant for consideration of both the appeals, in brief, are that on 6/7/2010, when the claimant late Nirmal Talukdar was coming from Bashishto Chariali to Beltola Tiniali in a motorcycle, as a pillion in a motorcycle bearing registration number AS01 AC 7454 as a pillion rider, and when the said motorcycle reached near SBI Beltola branch, an unknown motorcycle at the just after overtaking an unknown motorcycle, the said unknown motorcycle knocked down the motorcycle on which the claimant was riding from backside, as a result of which both the claimant as well as rider of the motorcycle sustained grievous injuries on their person. Stop. After the accident, the claimant was immediately taken to Agile Hospital at Beltola, and from there he was referred to GNRC Hospital for better treatment. Stop. In the GNRC Hospital, the claimant took treatment as an indoor patient from 6/7/2010 to 5/8/2010. Stop. A police case, that is Beltola PS case number 320/2010, was also registered in connection with the aforesaid accident under section 279/338 of the Indian Penal Code.
Against the unknown vehicle.
Stop. The next para. Thereafter, the claimant approached the Motor Accident Claims Tribunal number 1, Kamrup, Gauhati, by filing an application under section 166 of the Motor Vehicles Act, 1988, claiming compensation for the injuries sustained by him in the aforesaid accident. The driver and the owner of the offending vehicle, within bracket, that is the motorcycle bearing registration number AS01AC7454, did not, bracket close, did not contest the claim despite due service of notice on them, and as such, the inquiry proceeded ex parte against them. Stop. However, the appellant of MAC appeal number 336/2017, that is the Oriental Insurance Company Limited, National Insurance Company Limited, contested the claim of the claimant by filing written statement. Stop. Wherein contested the claim of the claimant by filing written statement, wherein it denied its liability to pay any compensation to the claimant. Stop. Next para. On the basis of the pleadings of the parties, the tribunal framed following issues. Quote A from page 7 from MAC appeal number 336/2017. Stop. In In support of his claim, the claimant examined himself as PW1 and exhibited certain documents. Stop. The insurance company also examined one witness as DW1 and also exhibited the FIR. You have exhibited only one document or uh, also exhibited the FIR as well as the written Ejaha filed in connection with the aforesaid case. Stop. However, ultimately, by the judgment and award which has been impugned in both these appeals, the tribunal allowed the claims petition and awarded a compensation amount of rupees 6,29,000 along with an interest at the rate of 6% per annum from the date of filing of the claim petition till payment to the claimant. The appellant insurance company was directed to pay the said amount. Stop. Miss R.D. Majumdar, the learned counsel for the appellant insurance company, in MAC appeal number 336/2017, has submitted that the tribunal, the Motor Accident Claims Tribunal, had erred in ascribing the liability of paying the compensation to the on the appellant insurance company without taking into consideration the fact that that this case was a case of hit and run by an unknown motorcycle. Stop. She submits that the evidence of DW1, wherein the FIR as well as the written AJR was exhibited by the witness for the insurance company, clearly shows that in the FIR it has been stated that the accident was caused due to an unknown motorcycle.
Chip, I have annexed page 17, annexure 3, the cross-examination of the claimant lordship. He also accepted that the case was registered against the motorcycle which knocked our motorcycle.
Stop. She further submits that the tribunal also did not consider the statement of the claimant while deposing as PW1, wherein he admitted that the police case was filed against. Which page you are referring?
Page 17, lordship, cross-examination.
Page 17 of?
Memo. This is typed copy. The handwritten copy is at page 18. The second, I do not know if FR was when filed was registered. I know the case was registered against the motorcycle which knocked our motorcycle.
Claimant made during his cross-examination as PW1 wherein he admitted that the police case was registered against the unknown motorcycle which knocked the motorcycle in which the claimant was riding. She submits that under such circumstances, the remedy, the proper course available for the claimant was to seek a compensation under section 161 of the Motor Vehicles Act. Stop. Continue, Kurim Chamber. I am reserving the judgment. I'll continue it later on. Heard, Mr. So and so. Hearing concluded, judgment reserved.
Nine reserve.
Lordship, I'm sorry, Lord. I'm sorry, Lord. Lordship, my last point was regarding interest, which I
For reasons mentioned, stated in the judgment, this appeal is dismissed.
Okay.
Statutory amount. It will be returned. For reasons stated in the judgment, this appeal is also dismissed.
deeply obliged.
Item P said to item 28.
Talking of ourselves. Yes,
May it please, sir.
yes.
Lord, day before yesterday, we had seen, my lord, from the additional documents that were submitted with the appeal memo, that there's a lot of tussle and dispute regarding the quantum of shares. Both the parties are alleging that there has been an illegal transfer of the shares in favor of the other members. Now, my lord, amidst all of this, my lord, the application was filed seeking a succession certificate in respect of a fixed number of shares.
3,100
And
and 9,000 of different 3,100 of which company?
Page 52, my lord, is the 3,100 of Mohijoli Tea Company, my lord.
And what about unsecured
Unsecured loan.
loan?
And two unsecured loans.
Is there any dispute regarding that also?
Yes. Nothing is admitted if your lordship sees the written objection. Now, my lord, of course, in the main succession application, now, my lord, page 57 is where your lordship finds the denial of both the shares and also the so-called unsecured loans.
Where you deny? In para
Para 6, subpara 2, subpara 3, 4, and paragraph 9.
the case setup in essence is that this is all a family run company. So therefore this distribution of shares, etc. is merely notional and it is only for income tax purposes. And then paragraph 9, the debts, the other debts have also been disputed. Now, my lord, one very significant departure that was made was in the succession application, my lord, their case is based on succession, that we are legal heirs of Adilur Rahman, which is why we are entitled to inherit those shares, my lord. Now, of course, there was no document on record to either prove the existence of the shares, the quantum of shares, or the unsecured loans, my lord. However, at page 157, my lord, an additional evidence on affidavit was filed
Right.
by the appellant.
Yes.
Now, in this, if your lordship sees paragraph 1, my lord, there was a significant departure in the sense that while the main application stressed upon the right through succession, in the additional evidence on affidavit, they claimed to be entitled to transfer of shares by virtue of a supposed minutes of meeting. Paragraph 1, if I may read, that after the death of my husband Adilur Rahman, a meeting was held on 18/2/2013 in presence of Mrs. Rubena Rahman, the Managing Director of Mohijuli Tea Company Private Limited, and Tejalpatti Tea Private Limited, in presence of one Nazimuddin Sheikh, the legal consultant of the company, and one Sanat Roy, the managing manager FNA of the company, in respect of, your lordship will mark the words, transfer of shares and unsecured loan of late Adilur Rahman in the name of myself and my daughter. In the said meetings, minutes were prepared and it was signed by Mrs. Rumena Rahman, the managing director of the company, and said Nazimuddin Sheikh and Sanat Roy. Now that memorandum, your minutes of the meeting, your lordship finds at page 160. After recording the presence of members, my lord, the following decisions have been taken and asked to proceed accordingly.
Yes.
Now here, my lord, clause 1 and 2, it says shares and unsecured loan of Adilur Rahman since deceased in Mohijuli Tea Company will be transferred in the name of wife Afroza and daughter so-and-so. Number 2, shares and unsecured loan of Adilur Rahman in Tejalpatti Private Limited will be transferred in the name of his wife Afroza and daughter Azana Rahman. The shares and unsecured loan are as under. There was no foundation for this evidence to be led as additional evidence, my lord. Anyway, my lord, I'll come to that because that sort of again negates their own claim of succession. Now to
No. This is the minute of the meeting of the board of directors of the company.
right.
This is on the basis of some entitlement or either as per this that company laws provision in section 45 or 46.
Yes, I'll come to that. That is why precisely I was showing it, Lord.
46.
Yeah. Now, if it's a case of transfer and transmission, my lord, this succession case will have no relevance. And if it's a case of succession, my lord, then it has to be purely on the ground of succession. I'll substantiate on that, my lord. If I may just quickly just indicate the other points, my lord. So when amidst all this dispute between the members as to who's entitled to how many shares, they simply file an application saying that I'm entitled to 3,100 in one company and I'm entitled to 9,000 in the other. Now, if your lordship has the Companies Act, because there has to be certainty, more so because there's an ongoing dispute regarding the entitlement to shares. Now, it was a total lack of particulars. So first, if your lordship has section 43.
Yes. Yes.
43, my lord, talks of kinds of share capital. The share capital of a company limited by share shall be of two kinds, namely equity share capital with voting right, or with differential rights as to dividend voting or otherwise in accordance with such rules as may be prescribed, and B, preference share capital, provided nothing in this act shall affect the rights of preferential shareholders who are entitled to participate in the procedure winding up before the commencement of the act. Now, equity share capital, preference share capital, all of it is defined, my lord. So this is insofar as types of shares are concerned. Now, if your lordship may skip over to section 45.
Yes.
45 deals with numbering of shares. Now, it says every share in a company having a share capital shall be distinguished by a distinctive number, provided that nothing in this section shall apply to a share held by a person whose name is entered as a holder of beneficial interest in such share in the records as a depository. That we are not concerned. Then 46 is the answer to your lordship's query as to who holds the share certificates. Now, 46(1) says a certificate issued under the common seal, if any, of the company or signed by two directors or by a director and the company secretary, wherever the company has appointed a company secretary, specifying the shares held by any person, shall be prima facie evidence of the title of the person to such shares. Number 2 is what was read out, my lord, by my learned friend. It says a duplicate certificate of shares may be issued if such certificate is proved to have been destroyed or lost or destroyed, has been defaced, B has been defaced, mutilated or torn or is surrendered to the company. 3, notwithstanding anything contained in the articles of the company, the manner of issue of a certificate of shares or the duplicate thereof, the form of such certificate, the particulars to be entered in the register of members, and other matters shall be as prescribed, as may be prescribed. 4 and 5, we are not concerned. Now, 47, of course, talks of voting rights.
So where is the provision of transmission of shares?
I'll come to that is 56, Malab. 56, if your lordship has.
Yes.
A company shall not register a transfer of securities of the company or the interest of a member in the company in the case of a company having no share capital other than the transfer between persons, both of whose names are entered as holders of beneficial interest in the records of the depository, unless a proper instrument of transfer in such form as may be prescribed, duly stamped, dated, and executed by or on behalf of the transferor and the transferee, and specifying the name, address, and occupation, if any, of the transferee has been delivered to the company by the transferor or the transferee within a period of 60 days from the date of execution, along with the certificate relating to the securities, or if no such certificate is in existence, along with the letter of allotment of securities. Provided that where the instrument of transfer has been lost or the instrument of transfer has not been delivered within the prescribed period, the company may register the transfer on such terms as to indemnity as the board may think fit. Now, my lord, this is concerning transfer of shares, my lord, and 58 is important here.
52 is, my lord, transmission. That is most important. Subsection 2.
56(2).
Subsection 2.
Subsection 2, my lord, nothing in subsection 1 shall prejudice the power of the company to register on receipt of an intimation of transmission of any right to securities by operation of law from any person to whom such right has been transmitted. 3 also I'll read, my lord. Where an application is made by the transferor alone and relates partly to paid shares, the transfer shall not be registered unless the company gives the notice of the application in such manner as may be prescribed to the transferee, and the transferee gives no objection to the transfer within 2 weeks from the receipt of the notice. Now, if I may skip over to 58 now, my lord, what happens if there's a refusal? If a private company limited by shares refuses, whether in pursuance of any power of the company under the articles or otherwise, to register the transfer or transmission, transfer of or the transmission by operation of law of the right to any securities or interest of a member in the company, it shall within 30 days from the date on which the instrument of transfer or intimation of such transmission, as the case may be, was delivered to the company, send notice of the refusal to the transfer and the transferee, or to the person giving intimation of such transmission, as the case may be, giving reasons for refusal. Without prejudice to subsection 1, the securities or other interest of any member in a public company shall be transferable, provided that any contract or arrangement between 2 or more persons in respect of transfer of securities shall be enforceable as a contract. 3, my lord, the transferee may appeal to the tribunal against the refusal within a period of 30 days from the date of receipt of the notice, or in the case no notice has been sent by the company, within a period of 60 days from the date on which the instrument of transfer or the intimation of transmission, as the case may be, was delivered to the company. Now, why I've read these provisions, my lord, just to drive home 2 points. Now, first of all, merely by stating without any document, to say that I'm entitled to 3,100 shares will not be sufficient. Number one, we've seen that what kind of shares you're staking claim over is essential, and I'll show from the Succession Act also, it has to record that detail. First of all, whether in respect of what kind of those 3,100 shares you're actually seeking the succession certificate, that is important. Number two, every share is numbered, so it has a distinctive number, which again, your lordship will find a corresponding schedule in the Succession Act, which has to show that distinctive number, my lord. Thirdly, my lord, to show that there is they are holders of a share, my lord, there has to be a share certificate, which is prima facie proof of the fact that you are a shareholder. Now, without these essential particulars, my lord, amidst all so many disputes regarding transfer, transmission, and entitlement to share, how does the learned court, trial court, issue a succession certificate blindly on the mere asking that I am entitled to 3,100 or 9,000 shares
No,
for
their
that?
case is that their father was holding this much of shares
True, my lord, but
of this company,
right. Now, what kind of shares?
which is not denied by the others.
There is no admission with subject to correction, my lord. Because, my lord, now if the father was entitled, at least there could be a share certificate in the name of the father. I can understand the transmission has not taken effect, or maybe we've only denied or refused the transmission. But at least that their father had this amount of shares of this kind, there is absolutely no document to that effect, my lord.
Then what this meeting on
Meeting, there is no foundation. We never had the opportunity of disputing it. All of a sudden, during the evidence, they have shown this particular minutes of the meeting. And that again negates their own case, my lord. Then it becomes a matter of transmission or transfer. If it becomes a matter of transmission or transfer, and I have actually refused to record that transmission or transfer, then you either go within 30 days from when I give you a notice, or if I don't give you a notice, within 60 days to the tribunal to effect that transmission.
which tribunal?
The National Company
Company
Law
law.
Tribunal.
Okay.
So these
They have in fact approached the tribunal.
that's there. So, my lord, these are mutually inconsistent, if I may say so, because if you're claiming right under that MOM, then your case is of transmission and transfer, and if there is a refusal, you must go to the NCLT. And if it's actually a case of inheritance or succession, like they call it, my lord, they'll have to show the antecedent fact that their father were actually in possession of this particular number of shares of this particular kind, whether with voting or non-voting rights. My lord. Now, this assumes importance because, my lord, if your lordship may have the Indian Succession Act.
Yes. Schedule.
Schedule 8, my lord. This is the form of certificate and extended certificate, my lord. As per section 377, the form reads as whereas you applied on the dash day of dash for a certificate under Part 10 of the Indian Succession Act in respect of the following debts and securities. Now, first, insofar as debts are concerned, my lord, it must bear the name of the debtor, amount of debt included, including interest on the date of application of the certificate, description and date of the instrument, if any, by which the debt is secured. Now, secured for securities, my lord, serial number, then second column, your lordship finds distinguishing number or letter of security. So, if this has to be read in conjunction with section 45 of the Companies Act, to give the number. Then, my lord, is name, title, or class of security. This again has to be read in conjunction with section 43 of the Companies Act.
What will happen if the petitioner who is praying for a succession certificate is unaware about the share certificates?
Then he'll either call for it or adduce secondary evidence, which your lordship's order had said, as your lordship then was, that you're entitled to secondary evidence to show at least the existence. Otherwise, how does the court even issue the certificate without filling in the mandatory columns as mandated under Schedule 7, Schedule 8, I'm sorry. It can't just blindly issue 3,100 shares of Mohy Estate without specifying the distinctive numbering of the security, the kind, the class. And this assumes a lot of importance because of the nature of the dispute, my lord. Because your lordship will appreciate one thing: if they get hold of a succession certificate for 9,003 or 3,100 shares, they can approach directly NCLT, because NCLT has already observed that you are not shareholders today. So, without furnishing the particular details, if they just get a blanket succession certificate, my lord, they'll still emerge before the NCLT, where there is already a dispute, ongoing dispute as to who's entitled to how much and whether there has been an illegal transfer of shares or not.
No, these shares are not transferred to anybody.
These shares are not transferred to anyone.
Yet to be transferred.
Yes, my lord. No, first thing, my lord, if I may say, whether the their predecessor were entitled, was the holder of these shares.
Is there any dispute between on that issue also?
My lord?
Is there any dispute whether Adilur Rahman held those shares?
How many? How many? What kind of? Which all? There is no admission in so far as these are concerned. That he is a shareholder, and we have also said that this is all very notional, and this is all because of the family, the nature of the company.
No, you have admitted that he holds
some shares.
Some particular numbers of share, only for the purpose of showing in tax
Yes,
return.
yes. Now
That
what-
is your stand.
Yes, yes.
So you are aware.
No way. But
Oh.
I've said you're not entitled to this much. Or, and I have to first know which are the shares you're saying, 3,100 of equity, preference shares, which all numbers, do you have voting rights, do you don't have voting rights, etc. Because that will have a bearing in the other proceedings also. Now, 372 also, Manoj, section 372. The application for the certificate also must contain
Yes.
at serial number 372(1)(d), the right in which the petitioner claims. So, is it inheritance? Is it transmission? Is it transfer? Is it on the basis of that MOM? That has to be mentioned in the application. And F, the debts and securities in respect of which the certificate is applied. Now, that description of debt and securities at least must have a distinctive number.
Okay. Where is the requirement of details of debts and security?
That is in the schedule.
Yeah.
But
What's
it
372F only?
F1. F1.
F.
F.
So
F doesn't say a distinguishing number, the form says.
it can be identified by numbers also.
Yes.
Suppose the succession court issues succession certificate to the effect that 3,000 shares held, which were held earlier by Adilur Rahman. In respect of those 3,000 share,
Yes.
succession certificate is issued.
Well, for that also, with the particular, ask myself this question, Manoj. First of all, there is no certainty that he actually held these many shares. There is not even a share certificate. And then, Malad, to just say, to issue a certificate of this nature, it cannot by any, cannot conform to that schedule even.
Schedule 8.
Schedule 8. Because it talks of distinctive numbers, Malad, which has to be read in conjunction with 45, which says that all shares have to be numbered.
Okay.
So my first submission is, Malad, there was hardly any clarity on what are the shares, did he actually hold them, what are the class of shares, and what are the numbers of the shares. There was nothing, Malad. Second submission, Malad, is that their claim, the
Whether
right.
in the office of the registrars of companies,
Yes,
these details are kept, that
yes, Malad.
who is holding which
Yes, yes, that
kind, descriptions of shares held by.
yes. Because we are supposed to submit returns, Malad. Those returns.
But in returns, you mention only numbers.
In returns, I think,
or details
because
of-
Form 20B now has undergone a change subject to correction, Manoj. But the Form 20B is relatable to Section 157 of the Old Companies Act. Now the forms may have changed, Manoj. I am not very certain on that, Manoj. Now, Manoj, second submission would be 372 also demands that you must disclose the right in which the petitioner claims. So here, Manoj, there's inconsistency in the sense that for succession, there is absolutely no document whatsoever. And secondly, Manoj, if it's transmission and transfer, like I've already said, Manoj, it's a case for you to approach the tribunal where matters are already pending.
Okay.
Now, this is again relatable to the first question as to whether they have been able to give any iota of evidence regarding the existence of the shares at all. Now, page 146 is the order which was passed.
Yes.
12, 11, 18, my lord. Second paragraph, the dispute is recorded, and page 147 is where it was held. It was ordered that upon perusal of the petition and the written objection, and upon hearing the submissions of the learned counsel, it is found that as the opposite parties have denied the existence it is found that as the opposite parties have denied the existence of such documents in their custody, so there is no any ground to direct the opposite parties to produce the documents in the case. The petitioner can lead secondary evidence in respect of the said documents, hence the petition filed by the petitioner is rejected.
This petition was to direct the other side to
To
produce.
produce. So now let us assume that they have complied with 66 of the Evidence Act for a moment. But then, my lord, what secondary evidence was led? There is absolutely nothing, my lord. Now, firstly, my lord, share certificate could have been the prima facie proof, my lord, which they did not produce, my lord. Given section 46, my lord, the share certificate is always with the holder of the share.
Yes.
So the question of duplicate shares being generated in favor of the legal heirs would come later, my lord. But if Adilur Rahman was the holder of shares, he should naturally have the the share certificate under 46.
And even if it is lost or destroyed, there is provision for duplicate.
Duplicate shares. That also no endeavor, no exercise has been made to that effect, or no evidence for that matter that I have lost it. Now, because ultimately, which situation under 65 are you trying to invoke? Because your lordship's order is very clear, you must lead secondary evidence. Now, if you
So
have
whether any secondary evidence was led
absolutely nothing, madam.
apart from what is produced
Here,
day before yesterday.
yes, nothing. And that is the same document which was perhaps we were not even present, which was presented to the court after arguments were concluded.
Where?
In the trial court. That is what the order records. We were not even put to notice, my lord, and therefore the court holds that page 191, my lord, the last line. Page 191, if your lordship says.
No secondary evidence.
The last but 5 lines, my lord, without distinctive. As your lordship found it?
Yes.
Without distinctive and identifiable numbers or certificate of the share, the court cannot pass a blanket order for issuing succession certificate. No secondary evidence in respect of the share certificate has been adduced by the petitioners. At the stage of argument, the petitioner side has submitted copies of Form 20B issued by the Registrar of Companies in support of the fact that the shares mentioned in the petition are lying in the aforesaid 2 companies. No permission has been sought for submitting documents submitted at the time of argument. Those forms have been submitted without there being any certificate under 65B of the Evidence Act. Since those forms have not been brought on record through evidence, other side has not got the opportunity to cross-examine those documents. Therefore, the same cannot be relied upon. As simple as that, my lord. That order of 12, 11, 18 merely granted them the opportunity to adduce secondary evidence. Now, if that merely said that they are at liberty to adduce secondary evidence. Now, to lead secondary evidence, it is elementary that you must first either say that it is lost or destroyed, or it is in the possession of the other party, etc., etc. Then the foundation has to be laid, and at least the least that is expected is that the second form 20B, if that is even considered to be a second, that has to be at least exhibited or marked as an exhibit by the witness concerned. Just pushing the document through the bar, across the bar, my lord, at the time of argument, how can it satisfy the requirement of section 65?
Okay.
Now, my lord, and that form 20B, my learned friend has said that it is a computer downloaded, so naturally requirements of then 65B of the Evidence Act, 63 of the BSA, etc. Nothing has been complied with. If it bears the seal of the authority concerned, then that authority, it has to be proved that it is the seal of that particular authority. Nothing is there, my lord, simply. So ultimately, this application, if not for anything, has to be dismissed on the ground of vagueness itself, my lord. First of all, they simply file an application. We are entitled to 3,100 and 900 shares. No details whatsoever. So it lacks clarity. Number two, do you have any document to show? There is absolutely none. Share certificate, the holder of the share should have. Instead, they are calling it from the other side, my lord. Then also thereafter the court says that you lead secondary evidence. No secondary evidence, no foundation is laid, my lord. So how can the court just blindly issue a certificate merely on their asking? That too at this juncture when there's a long tussle between who is entitled to how much, my lord. And even otherwise, my lord, succession certificate would not have been issued, like I've already said, without those distinctive numbers, because tomorrow they'll create a whole lot of confusion. When they approach the NCLT with that succession certificate, if at all a certificate is issued that I am entitled to 3,900 shares, therefore I have now become a member. Amidst so much of vagueness, my lord. Because if your lordship must have seen page 116, paragraph 14, it has been clearly recorded that they are not shareholders. So which is why they are contesting this so hard, because they want a succession certificate. My lord, it is as good as, my lord, just to give an example.
116 paragraph.
116 paragraph 14.
What is this?
This is the order by the NCLT, which categorically held that they are not shareholders of the respondent company. Of course, my friend has stated that this has been interfered with by the NCLAT, which we are not aware. So this order clearly records. Now,
Yes.
now, my lord, just to give an example, my lord, all debts and securities, there can be a succession certificate, my lord. Now, this is a company dispute. We, the opposite party, also happen to be the legal heirs or the members of the company. Therefore, we were put to notice, my lord. Just for example, my lord, if there's a policy, LIC, if they pray for a succession certificate for an LIC, LIC is not even there. They don't annex the policy number. They just get a succession certificate that my forefather or whatever, my predecessor had a sum assured of 1 crore. So kindly issue me a succession certificate, but I don't have the policy number. I have nothing. But then my lord,
It is on that ground only the trial court.
trial court has said that. Because and more particularly when there's such a contested litigation going on.
Okay. Anything else?
That should be fine.
Any reply?
Yes. 5-6 minutes. My learned friend, actually, I'm grateful.
You have not exhibited any secondary.
I'm coming to that. I'm coming to that. My learned friend made our task very easy. He has categorically stated that I do not have any share certificates. That's true. I have not produced that. He has categorically stated that I do not know the distinctive number. That's true. Because
No.
unless and until I have the share certificates,
But for seeking succession certificate in respect of any debt or security,
yes,
you have to give details thereof to the court. And you could have obtained the share certificate from registrars of
not
company.
registrar cannot issue the duplicate share certificate. Only the company. And
Or-
this is
or
the most
from
important aspect, that what is the company? My learned friend says that I failed to produce share certificate, so we do not know how many shares or whatever were purchased by my father. He's right. I do not know the distinctive numbers because there are no such share certificates. That is correct.
Who accord distinctive numbers? Who gives this distinctive?
That is company.
Company
In the
or
company, in the register of members, what we do, we create different folios. Like say folio number 1 for my grandmother, folio number 2 for my father, folio number 3 for my learned friends, that is my uncle, and then folio number 4 for my aunt, that is Bua. And in all the folio numbers, the number of shares, 1 to say 3, my father was holding 3,100. So if the first shares were issued, first share was issued to my grandmother, say 1 to 40,000. So 1 to 40,000 is the number for allotted to my grandmother. Then thereafter,
what will be the distinctive numbers?
that is what 1 to 40,000.
Okay.
1 to 40,000. And for me, for my father, then from 40,001 to 43,100.
Okay.
And similarly for my uncle and for my.
So in the annual return, which you file before the
It is not there. It is in the register of members only. Initially, when we incorporate the company, I have brought the memorandum and article also.
No, for transferring the shares of a company.
Yes, when we are transferring.
You have to mention.
When we are transferring, then that requirement is there, that is called SH4 method. I'm talking about transfer, not transmission. Transmission does not require. I'll come to that within a minute. Let us understand the transfer mechanism. If I have to transfer my shares to him, I'll sign SH4. He will also sign SH4 as a transferee. I am the transferor. My learned friend will sign it as a witness. And with that, share certificates or whatever I have or allotment.
Wherein you will mention the details of the.
In the SH4, yes, SH4. And
giving distinctive numbers.
Yes. So with that SH4 will be filed with the company along with my share certificates. Board will call convene a meeting. They will examine my share certificates. They will examine that SH4. If there is no doubt, if they know that they know me, they know the transferee, they know my learned friend who is a witness, then transfer will be effected immediately.
In the register.
Yes, Lord. In my place, his name will be included without any problem. If I am not holding any share, then my name will be deleted from them. But I'm raising a fundamental question, Milord, about my learned friend. My learned friend says I do not have share certificates, correct? I do not know the distinctive ones, correct? He did not allow this transmission because of these 2 reasons. He was very categorical with that. Now I ask a question. Does he have the share certificates? Does he know his distinctive number? Because if I do not have share certificates, I am not a shareholder. If I do not know distinctive number, I am not a shareholder. If he does not know, then he is also not a shareholder. Then on what basis he appeared before the court and objected to that, to the issue of succession certificate? Why I am saying this, my lord? My learned friend forgot his own pleadings. Come to page 144. Para 7. When I led my secondary evidence, which was allowed by the court, which is at page number 156. At 156, on the learned court has categorically stated that I was allowed to lead my secondary evidence of that board resolution, my lord, Xerox copy of board resolution. That permission was granted to me. When I filed that, then my learned friend filed an objection to that. And in the objection, what he is writing, kindly come to page 144, page para 7. Para 7. after my lord 1, 2, 3, 4, after 10 pages, 10 lines, what he is writing, the opposite parties say that share certificates to the shareholders. Now all shareholders, my lord, my grandmother, my father, my uncle and my aunt, all four were shareholders. What he is saying? The opposite parties say that share certificates to the shareholders who do not have been issued as the certificates were out of printing. Not my statement, my learned friend's statement. That means no share certificates were issued to anyone. Now, I do not have share certificates. I am not a shareholder. How is he a shareholder? And on what basis he went there and contested? This should have been examined by the learned court. That none of the parties have share certificates, because I have been denied that succession certificate only on the ground of no share certificates. He has just stated that no share certificates. If I read that para 191, my lord, kindly come to 191.
So main ground for denial was not properly identifying the
petitioner have also not submitted any document regarding above that. The petitioners have not disclosed either. No, wait. Just yes. The petitioners have also not submitted any documents regarding existence of unsecured loan in respect of which succession certificate has been sought for without distinctive and identifiable numbers or certificate. That is the finding of the court. That without any distinctive number or I could have at least stated that yes, these are the distinctive numbers of the shares. I do not have the share certificates because or is used by the learned court or the certificate. So because I didn't have the certificate and also I didn't know the distinctive numbers, that is why my petition got dismissed. Now my question is, my lord, then on what basis he contested that petition? Because my learned friend does not have share certificates. My learned friend also do not know his own distinctive number of shares. He has stated before the court. Now, my lord, come to 144, 146. This is even more important with that. 146, almost the last line, my lord. And the opposite parties are not the custodian of the documents relating to share and unsecured loan. Now, who are custodians, my lord? Section 179 of the Companies Act. It says that board of directors are authorized to do what the company is authorized to do. Your lordship may just peruse that. Section 179. Earlier, it was 291 of the Companies Act 1956. So board of directors are the custodians. They are entrusted with all the assets and properties of the company and they are supposed to manage the company. Now he says that I am not the custodian. So he is neither a shareholder nor a director in the company. He went before the learned court and contested my case.
So on what basis you are saying that your father held this much numbers of shares?
Now here comes the annual return.
But that annual return is not.
That was submitted. It is admitted in the order, my lord. It is admitted in the order that it is submitted. Page number 192.
At the time of argument.
Exactly. Now, whether it is secondary evidence or it is something else, that is the question to be decided, my lord. Now, before I answer this, my lord, when I was arguing my case before, when I concluded, in fact, my arguments before the Honorable NCLAT.
So, is it your submission that in such a circumstance where the company concerned is unable to give intimation regarding distinctive numbers, the succession certificate may be directed to be issued even by mentioning the numbers of shares held?
Because if there is a dispute or it mismatches with the records, the matter will go to NCLT. As simple as that. Because succession court is not deciding any dispute between the two parties. Not at all. It is only issuing a succession certificate. I'll go with the succession certificate because they want it.
But it must have some basis for issuing.
Annual return is the basis. Why I'm saying I'm coming to that, Milord. First, what is the requirement of section 56 of section 2 for transmission? Does it say that I'm supposed to give the share certificates or anything else or any document? It doesn't say.
Says that by operation of law.
By operation of law.
But
it is Succession Act. It is simple Succession Act. My father is having
invoke that provision
yes.
by operation of law.
Yes.
You have to plead certain things that.
To whom, my lord? That's very important. To whom?
Before the
To Tata
succession,
Steel, it's okay because Tata Steel does not know me. But in a family company, they have admitted that these 5 are the family members of the company. He has admitted that I am the daughter of my father. My father was his
no, but
elder brother.
but they are disputing the numbers of share you are saying that your father
Yes.
held.
Yes. Ma'am. Then there was section 30. Ma'am. First of all, they have no right because we are equal. They do not have a share certificate. I do not have a share certificate.
But
They do not know.
they have not come for succession certificate.
Coming to that, they went for succession in a separate petition, my lord. That has been dismissed. That has dismissed by Honorable High Court. That's a different matter. I am not going into that. First, we are at a parity. I do not have share certificates. He does not have share certificates. I do not know distinctive number. He does not know distinctive number. That means neither I could get the succession certificate, neither he had any right to contest that. On what basis he contested that, my lord? If he is not a shareholder, if he is not a director, he himself says, I am not a custodian. He himself says, I do not have the share certificates because shares were never issued. Then on what basis he contested? That was the question. Locus was required to be examined by the learned court, which was not examined. Now I am coming to section 30, my lord. It is solved by only referring section 30. My lord, I went before the learned court for a succession certificate. I had no.
What is this status of the litigation before company law tribunal?
I'll come to that. Just I finished 30, my lord.
Yes.
With your lordship's permission. Section 30, my lord. Not only
30 of?
Section 30 of CPC.
Oh, yes.
Not just 30, my lord. Even, my lord, order 10, rule 14, order 16.6, order 13, rule 10. There are so many my lord, powers of the learned court to, my lord, just summon or even direct registrar of companies, which is the custodian of all the documents of all the private and limited companies of this country, right from the incorporation.
No, therefore, I was putting query whether these details are there with the registrars.
100% there. All these details are 100% there. And if the ROC issued a certificate, I gave one certificate, I am having another certificate. I gave that certificate that was not accepted because there was no permission of the court. So it is to be examined whether a permission was required of the court, whether that is a secondary evidence which the court could reject. And if there was nothing, suppose court has a doubt, complete doubt, that whether he has a locus to contest that or not, or whether I have a locus to seek succession certificate, the best place was, my lord, ROC. A notice could have been issued that there is a dispute between two parties. Both the parties claim that they are shareholders of this company or these two companies. Both of them claim that they are members of the same family. I am not sure that whether he is telling the right thing or he is telling the right thing. You bring your records kindly.
Where is the power?
Section 30?
30.
Section 30, my lord. Order 10, rule 14. 16.6, my lord. 16, order 16, rule 6. Learned court could have summoned also ROC. You come, bring your record, just show me and I'll pass an order. Because it was the most benign order. It was not deciding any right. It was not adjudicating any dispute. It was only giving me a certificate.
Section 13, and apart from that, order 10?
10, 14, my lord. Order 10, rule 14. In fact, order 10 and rule 14 I invoked, and in which I was directed to produce secondary evidence. Huh? Oh, sorry, I beg your pardon. Order 11, rule 14. Order 11, rule 14, order 16.6, rule 6, and order 10, 13. No, order 10. Order 10 is okay. Rule 14.
Okay.
That is the you filed on in that.
Okay. Anything else?
Yes, ma'am. When I concluded my argument before NCLT, I was just referring that. Then learned justice, retired justice of Delhi High Court, he inquired from them, are you keeping the shares still in the name of a dead man? How many years, my lord? 13 years. The certificate can be issued within 3 to 6 months, not more than that is not worth that, this proceeding, but continued for 11 years.
Who
Why
is,
was
ho-
the court
who is
astonished?
holding those shares now?
Who shares, my lord? My father, it is still in the name of my father. A
Is
dead
it?
man is still appearing in the records of the ROC because it has not been changed. If ROC comes today before your lordship, my lord, it will show late. ROC does not know about death and etc. That could have been informed only by the company. So ROC knows that this person is still alive and he is holding 3,100 shares in the company. And why, my lord, this was the astonishment of the court, and why at para 11, learned NCLT has categorically stated that shares of my father and shares of my grandmother have not been transmitted, and no reason has been assigned, no valid reason has been assigned by the company. That is completely illegal. This is a finding of the learned NCLT at para 11, my lord. I referred that day. My lord, why did they refuse to transmit them?
No, one more query.
Yes.
The company has to file annual return regarding details of its
Correct.
shares
And
holder.
who filed that?
And what they are filing, who is holding the?
Who is holding what and what they have, my lord, filed? What they have filed? They are signing? They are not. They have no authority to sign because I am entitled for 100% shares. So for in last 13 years, they have misappropriated entire profit. That is the only reason my succession, the shares were not transmitted. So 50 crores they have siphoned in 13 years. And that's why Honorable NCLT was astonished to hear that the shares are still, there is no provision in 56(2), my lord. It says that the moment I communicate with the company, company is bound to, my lord, because I mean, sent the death certificate. They also have a death certificates. They are the relatives. They also have the death certificates of my father. So the moment company receives that, his name was supposed to be deleted, and my name, legal heir's name, was supposed to be included. That is 56(2), nothing more. 56(2) does not allow them to call for any detail from me to, my lord, delay it after they were informed about the death and keep the shares in the name of a dead man. It does not allow. Because that is simple succession act. I am the legal heir, and you say that I am your niece, you are my uncle, and still you say that you bring a succession certificate. I will not allow transmission of that, and not in 3 months, 4 months, 6 months, but for 13 years. Now, my lord, I conclude with 3 judgments, my lord.
Yes.
And just five more minutes. Can we just give that 7 Allahabad judgment? My case is, my lord, covered under section 77 of the Evidence Act, my lord. Allahabad. This one. You have to write. Right. 1955. इसको दिखा दो. हाँ, so 1955 0 Supreme 7. Para 29 million. It has invoked section 77 minutes, so that's why I'm not reading the section. Section 77 Evidence Act laid down such certified copies may be produced in proof of the contents of the public documents. ROC, all records with ROC are public documents, or parts of the public documents of which they purport to be copies. Next, para lordship. Para 29. Para 29 is actually verbatim of section 77 of the Evidence Act. Nothing else. Para 79, para 30, section 79 is important. Evidence Act lays down that the court shall presume every document purported to be a certified copy duly certified by the officer, that is ROC, authorized in that behalf to be genuine.
Their objection is not on that line.
Yes.
Their objection is on a different line.
Yes.
That even if admitting that you have some secondary evidence, it has to be.
Public document is not a secondary evidence. That's my line of argument.
Okay.
Public document is not secondary evidence. Secondary evidence will have to follow, my lord, CPC. I agree with that. Now kindly see, And I'll come to that also. The effect of this provision of law would be that,
Has to take judicial notice.
yes, and this is a public, where is that? 16, no? Para 16. This quarter. And this is also decided by the Honorable Supreme Court.
What 70, para 30 says?
Para
30 of the judgment.
30, that it is genuine. If it is a public document certified by the authorized officer, then it is a genuine document. It has to be taken, my lord. Your lordship is still reading that. The effect of this provision of law would be that once a certified copy of the judgment is produced in court, it would have to be presumed as a genuine and would prove itself. No further proof of its genuineness would have to be needed, as the certificate appended to it would in law itself constitute a sufficient guarantee of its correctness of the copy.
Yes.
Now kindly come to para 16 of this order, my lord. Anita Malhotra. It has referred Evidence Act also. I'm reading the entire para, my lord. I'll take 1 minute time. Para 16. A reading of the above provision makes it clear that there is a statutory requirement under 159 of the Companies Act that every company having a share capital shall have to file with the Registrar of Companies an annual return. That is 20B, which I produced before the court, my lord, at the time of hearing, which includes details of existing directors. The provisions of Companies Act require the annual return to be made available by a company for inspection, as well as Section 610, which entitles any person to inspect documents kept by the Registrar of Companies. The High Court committed an error in ignoring Section 674 of the Evidence Act. Subsection 1 of Section 74 refers to the public documents, and subsection 2 provides that public documents include public records kept in the in any estate of private documents. A conjoint reading of Section 159, 163, 610 of Companies Act, read with subsection 2 of Section 74 of the Evidence Act, makes it clear that a certified copy of annual return is a public document, and the contrary conclusion arrived at by the High Court cannot be sustained. Now, my lord, this is the latest judgment. Whether a consent was required for filing that, my lord. Even if that is presumed to be a secondary evidence, my lord, whether any consent of the court or permission was required to be, my lord, sought for. Para 22, my lord, of Dhanpat. There is no requirement that an application is required to be filed in terms of Section 65C of the Evidence Act before the secondary evidence is led. A party to the lease may choose to file an application which is required to be considered by the trial court. But if any party to the suit has laid foundation, important manner, laid foundation of leading of secondary evidence, either in the plaint or in the evidence, the secondary evidence cannot be ousted for consideration only because an application for permission to lead secondary evidence was not filed. And my last item, page 160 of the petition, of my appeal petition. Sorry, एक और है ना 47, 41, 27 का एक order है ना, उसको बाद में सबसे लास्ट में, हाँ, बैंक तक के नीचे, not any document. This one? नहीं, हाँ, महावीर सर. I'll read this the last, but kindly see just page 116. This document was, I was directed, my lord, page 156, first page for 56, 156. This is the order of the learned court. In view of the said order, I find that there is no ground to reject the application filed by the petitioner allowing him to lead additional evidence on affidavit in respect of the said two documents, namely the minutes of meeting dated 18/2/13. And accordingly, the petition filed by the petitioner is allowed to that extent. So I filed this, my lord. I was allowed. I filed this. Now this is the document. And when did I file, my lord? That date is important. Now see, in the end, my lord, when it was certified, compared with the original and date of comparison, my lord, 1/3/19 at the end of the document on the left side, my lord, compared with the original 1/3/19,
Yes.
right, my lord? When was it filed? 1/3/19. Who signed this document? My grandmother, Rumena Rahman. When did she die? On 21st 9 2020. So after filing this, she survived, my lord, for 1 year. Now, if this was forged, my lord, then my grandmother should
When
have been
Rumena Rahman died?
Pardon, my lord?
When Rumena Rahman died?
21/9/2020 during the COVID period, my lord, because of the complication of the COVID, my lord. So it was filed in March, I beg your pardon, my lord. 1st March 2019, immediately after this certification, it was filed. So in March 2019, it was filed. She survived 1.5 years. If this document was forged, my lord, the person was alive. Honorable court should have summoned her immediately. That come and depose whether it is true or false. Another important aspect, my lord. Section 118 says that the company is supposed to maintain the minutes of board meetings and also general meeting. Section 118, it is statutory. It is required to be maintained. Company should have been summoned to bring the register of board meeting. That's it. That could have revealed. And if there was any, my lord, problem with that, say one paper was torn or something like that, then ROC could have been summoned, because in the annual return, we are detailing the number of board meetings and also the date of AGM, etc. Complete detail. So before ROC, being custodian, could have, my lord, said every aspect of this dispute, there was no need to linger it for 11 years. One, my lord, summoned to ROC could have revealed everything. And lastly, though not required, your lordship knows it well, but this is my duty to do. Is there? This is just, my lord, reproduced order 41, rule 27. And even if your lordship can ignore everything, whether there is still any impediment, para 5, my lord, and I am reading sub rule 1. The court from whose decree the appeal is preferred has refused to admit evidence which ought to have been admitted. So I produced, my lord, annual return. Court said, no, I will not admit because it is not, you have not been allowed to file this, or you have not sought the consent of this honorable court, and then comes to a conclusion that I had no evidence and therefore my petition got dismissed. I conclude with this. I'm so grateful.
Mr. S. A.K. Srivastava, the learned counsel for the appellant. Also heard Mr. B.D. Decker, the learned counsel for the respondent. Hearing concluded, judgment reserved.
Obliged. Grateful.
Yes.
It was earlier, it was part heard. And argument, written argument also submitted. But
Started before which court?
my lord,
Which court? Some other court.
justice.
Some other court. You need not come here.
Other,
Yes.
I have already submitted written argument also. In this case, what happened, my lord, in the case in appeal number 545,
Where is your written argument?
written argument is there, my record. On the point of, my lord, income. I'm the point of income. My lord. I have filed this 19/6/25.
Okay, what is your submission?
Well, in this case, my lord, whatever, I have submitted, exhibited one document, exhibit number 6, income. That was issued by the circle official. After due verification, that was issued. That is the public document because the income certificate was issued with number, memo number and date. That is the public document that was not considered by the trial court, my lord. But that,
What has happened in this? Why you have filed this appeal?
my lord,
For
for
enhancement?
enhancement of my amount, commission amount.
No.
My income was calculated as income certificate was issued for that showing that by that minor that the victims deceased person's income was 50,000 per month. 15,000 per month. That certificate was issued, but court has considered only 5,000 per month.
On what basis?
My lord, that is the in judgment in the judgment court judgment issue number 2.
That is the only ground. That
My-
is the only ground.
That is the only ground. My income is 15,000. That was not considered. My had relied on judgment, my lord. In this case, what
No,
happened?
before you rely on the judgment.
My lord,
Oh, how the tribunal assessed your income, which is the portion?
without discussing, my lord, that is the my lord, in paragraph in the judgment
Which
issue number 2, it was decided, it was discussed, my lord.
Which para?
Para number 8, judgment in the judgment of the trial court, issue number 2.
Para number 8. Yes, read para 8.
My lord. In the written statement filed by the opposite party, which is the insurer of the offending vehicle, the existence, the reality of the policy covered by the track has not been denied and no question of such has been disputed. The same during cross-examination of 3 witnesses was claiming, as such the opposite party is likely liable to compensation to claimant. In the claim petition, the age of the deceased has been claimed to be 36 years at the time of death. The same has been reiterated in the evidence of PW1. Driving license of the deceased has been exhibited exhibit 1, wherein the date of birth of the has been recorded as 10/12/73, which means that the deceased was 36 years age at the time of death. The post-mortem report mentioning 37 years, which however does not affect the claimant's case, as the applicable multiplier would be the same in both the cases. It has been stated in the examination in chief, the PW1, that there are 3 dependents of the deceased. She has claimed the monthly income of the deceased to be 15,000 at the time of death of the deceased. No credible documentary evidence except so-called income certificate issued by circle officer of the Deragaon revenue circle has been exhibited. However, keeping in view the time of his death, the number of dependents the deceased was having also in view of the fact that he was maintaining a tract in the name of his wife, ownership of which has not been challenged. His net income can be taken as rupees 5,000 per month. In view of the age of the time of death, 50% reduction of this. That is the ground on the my not considering my income certificate. That is the issue. Certificate was issued by the authority after due verification. And I have relied on judgment, my lord, if the
they have any doubt upon the genuinity of this document, they could have called the officer who has issued the certificate. But they did not, the insurance company has not examined any person. Because this is the public document, my lord. So once it is issued by with memo number and date, after due verification, it is public document. There is, if there have any doubt of genuinity, that is the judgment. In my judgment, that is the, I have annexed this judgment in my written argument, last written argument, in my written argument, in last page, my lord. In fact, the permission was not regarded as the area falling within the.
Just a minute, where are you reading? Which judgment?
My lord, judgment. I have annexed. My lord, Prithi Singh versus Union of India, 1958, legal Manipur 34.
Para?
Para, my lord, page, judgment page, my lord, was 6 page, my lord. Para 14. Para 14. This is a case of, my lord, one permission. Regarding permission. In fact, the permission was as regards the area falling within the Judicial Deputy Commission of the Nagal, since the order was duly numbered, dated, and purported to be signed by the ADC for the DC and bore the official seal of the officer. I am of the opinion the permit part of the document was a public document within the meaning of Section 74 of the Evidence Act. It did not thus require any further proof, and if the prosecution doubted its genuineness, then it was for them to have called the officer whose signature the document purports to bear and have laid evidence in support of their.
No, where is the judgment? I'm not getting that.
My lord.
এই রেকর্ড করা রিটেন আর্গুমেন্ট আর জাজমেন্ট রিলেক্ট করেন।
Since it was issued by the authority after due verification, there should not be any doubt upon that judgment certificate, my lord. But that was not considered as trial court. And fixed the income of the deceit as 5,000 per month.
Yes. Anything else?
My lord.
No. Yes, miss.
Only my.
Lordship, what my friend is submitting is that is the judgment is totally not related to MB Act, Lordship. Thing is, in this case, the certificate was proved by the handyman of the vehicle. I'll go to his evidence also. In my case also, it is important. I'll go to his evidence. Circle officer did not adduce any evidence, Lordship, about the income. The certificate was issued after the death of the deceased, Lordship. So how that can be accepted? And Lordship, in his appeal only, Lordship, let's come to page 6.
There are two appeals.
Two appeals, one by them, one by us.
They are for enhancement and your appeal is for?
For reduction because on negligence part, Lordship.
Okay.
Lordship will come to the judgment, the calculation of compensation in their appeal itself, because the compensation has to be just compensation, Lordship, not a bonanza. Lordship, the calculation is made at internal page 6 of the judgment, Lordship.
Yes.
Lordship will find that funeral and other expenses, loss of estate, loss of consortium to wife, loss of love and affection to minor child, loss of care and affection to parents, Lordship, it has come to 3,35,000. This needs to be reduced, Lordship, as per pronounce, Lordship. Now it will be 84,000 some, 84,800 because I don't know, yeah. From 70,000 lordship, the 3 years, and again the 3 years enhancement in another case, apex court has referred it to a larger bench lordship. That is also in question, but still lordship. So this amount lordship in their appeal itself, I'm submitting that this amount deserves to be deducted lordship. So lordship for the income lordship, the cross of PW3 lordship. He is the handyman of the vehicle lordship. PW3 lordship, page 57 to 60 is the cross examination lordship LC.
Yes.
Lordship. He says, I cannot say whether in the FIR or claim petition it was mentioned that I was a handyman in the vehicle. I have not submitted any paper showing my applicant getting salary, a handyman of the vehicle. I have not given any statement before police at the time of accident. I have not submitted any paper showing getting any injury. I have not filed any claim petition for my wounds, lordship. This for our appeal lordship, this next sentence. It is not a fact that I saw the parking light was on. Before the accident, I was standing by the side of the vehicle and not on the vehicle as stated in the evidence. This part for our appeal lordship, this part is important because rational negligence we are saying about the light being on. He was they have shown him as the eyewitness. He was present in the year. So he in cross-examination, lordship, we demolished the evidence in chief by the cross-examination. And cross-examination, he said that it is not a fact that I saw the parking light was on. Then further I read, lordship, deceased was not my relative. Exhibit 6, this exhibit 6 is the income certificate, was given to me by the claimant. I have not collected the above certificate of the office of the issuing authority. Exhibit 6 is not admittable document and I am not authority to prove the above document. It is not a fact that at the time of accident I was not there and came to depose falsely for the claimant. I have not received summon from court, lordship. The exhibit 6, what my friend is saying about the exhibit 6, the income document, lordship, this handyman exhibited it, and he himself in his cross-examination is saying that this is not a document. He is not the authority to prove it. The author of the document has to adduce evidence. It is not a public document, lordship. They got the document just because they applied, and they applied it after the death of the deceased, lordship. Exhibit 6.
Okay.
Our appeal is on ration negligence as well as quantum. Now I come to my appeal, insurance company appeal.
Appeal is
That appeal is lordship 177 of 2015.
177.
We filed earlier than their appeal, though theirs is coming in front.
Yes.
Lordship, our ground is, we are, in fact, they are questioning 5,000. We have questioned how 5,000 is given, Lordship. Because Lordship, the accident was 2009. Now it is settled law that the minimum wages is to be taken if they cannot prove the income, Lordship. So minimum wage at that time was 3,000 something, Lordship.
Okay.
Then my B ground, Lordship, I just read, Lordship, that PW2 has said that the parking light was, parking light was not on his cross-examination.
PW3.
Lordship,
PW3.
sorry, PW2 we have written, it is PW3, handyman.
No, is it 2 or 3?
3, Lordship,
Okay.
3. In C, it is written correctly, Lordship. Then, Lordship, the time of accident, Lordship, I'll read the judgment also. It is important, 12:30 AM. That means at night, Lordship. Date of accident is December 28/12/2009.
Yes.
Our ground C is that the court has not looked into the evidence cross-examination part of PW3, Lordship. And then, Lordship, the court has deducted 1/4, saying that there were 4 dependents. But, Lordship, in the cross-examination of the claimant herself, she said she has filed, I am the sole claimant of this case in her cross. I'll read that cross-examination. I am the sole claimant in this case.
No, she may be the sole claimant, but they may have more dependents.
Even if they have more dependent, Lordship, then it will be 1/3, not 1/4. That is what is our submission.
How many dependents were there?
They have not mentioned those dependents, but the court has said about a daughter. But I think it is not a daughter, it is a son. Court is wrong in that also. A son, maybe the mother, Asil, or wife. So 3 dependents. Father won't be dependent.
Okay.
That is why, Lordship, our ground is regarding 1/4 is to be removed to 1/3, Lordship. This is our main ground, Lordship. So should I read the judgment or I go straight? Oh, future prospect, another ground, thank you. Yeah, future prospect is given as 40%, it should be, sorry, 50%, it should be 40% as per Pronoicity and Sarlavan.
Okay. Anything else?
And Lordship, the amount already in their appeal itself, I have told the amount 1 lakh, 1 lakh, 1 lakh as per Pronoicity, now that is changed. So,
Yes, any reply?
Lordship, can I submit a judgment
Yes.
on ration negligence, Lordship?
Yes.
That is there. This is a very recent judgment of the apex court, Lordship, paragraph 14 and 15, wherein what happened, Lordship, in this case, a truck was standing. In our case also, the truck of the deceased was standing, and the vehicle insured with our company had come and dashed it from backside. And the court held that totally responsible, our vehicle is responsible for the accident. I showed, Lordship, from the cross-examination that the lights were not on of the truck, which was driven by the deceased, Lordship. So he contributed to the accident, and Lordship, in this judgment, I'll go to paragraph 14 and 16. I'll read just.
How accident happened?
Lordship, their truck was standing on the road, and our truck came and dashed it from backside.
And where was the deceased?
Deceased was
He was outside or
outside.
unity.
Okay.
Just left side.
He just parked the vehicle.
And
That is why.
the vehicle fell upon.
That is why
Okay,
in the cross-examination, we have brought in the parking light, that the parking light was not on. Because he was the handyman, he said that he was present at the time of accident. He was the eyewitness. So, Lordship, paragraph 14 and 15, I'm reading of the judgment, Lordship. In this case, the one I'm reading, Lordship, in this case, the truck was parked without the light. The wagoner came from backside and hit. Recently, this judgment is passed by Apex Court, Lordship, wherein it was made clear that just because a vehicle is coming from backside doesn't mean that it was responsible. Here, totally the wagoner was exonerated, Lordship. But my submit because we have already আমি pay করেছি না আপনাকে কিবা একটা 7 lakhs pay করেছো lordship my submission will be that not total but contributory negligence is to be taken into consideration, lordship. We have already paid them 7 lakhs of rupees. Lordship, paragraph 14 and 16 I'll read, lordship, of this judgment.
Yes.
Insofar as the question of negligence is concerned, we find no reason to take a view different from that currently taken by the tribunal and the High Court. The evidence on record, particularly the testimony of Nikhil Gumla, who himself was an injured eyewitness to the occurrence, established that the offending truck had been stationed on the road without parking light, indicators, reflectors, or any cautionary sign. The accident having occurred at about 3 a.m., the absence of such warning measures assumes significance. The said testimony has remained materially unshaken. Then 16. The mere fact that the wagoner collided with the truck from behind cannot by itself lead to an inference of negligence on the part of its driver. The issue of negligence has to be examined in the totality of circumstances. A stationary vehicle occupying the road in the dead of night without any warning indication poses an evident hazard to road users. The tribunal and the High Court have, on appreciation of the evidence, rightly concluded that the approximate cause of accident was the negligent acts of the truck driver in leaving the vehicle unattended on the road without adequate precautionary measures. So this Lordship judgment squarely covers our present case, Lordship, where the negligence of the deceased that he had parked his vehicle without a light, as I showed from the cross-examination of the PW3, Lordship, that he was himself negligent in parking the vehicle in that manner. The time of accident is 12:30 and in the month of December, Lordship, 28 December. It's very cold. And the place, Lordship, of accident, Kukan Pukri, Sipsagar, Lordship, while going from Dergaon to Mora.
Any reply? Anything else you want?
Lordship, my contention are that there should be reduction in the compensation. We have already paid them 7 lakhs of rupees. Our liability will not be more than that. And because of the contribution made by the year, and because 1/3 is to be deducted and 40% is to be added for future prospect, not 50%. The calculation is not correct, Lordship, as done by them. And also I showed that 3,35,000 that is granted, that is not correct. No. It should
My lord, so far this contributing negligence is participation that is discussed by the court itself, trial court itself. My lord, in paragraph, my lord, in page 3, paragraph, my lord, 7, issue number 2. That is, here it is discussed. During the cross-examination, the opposite party number 1 has given the suggestion, only suggestion that the accident was caused due to negligence of the deceased himself. No evidence as such has been laid by him. My lord, no evidence. Suggestion is not the evidence. They have given suggestion that it is not fact that a parking light was on. It is not. It is a suggestion only. They have not given any evidence. No, how it can be?
But your
My lord,
PW3 has admitted.
my lord.
PW3 has admitted that parking light was.
No, no. It is not admitted, my lord. Suggestion was given, my lord.
Let us see.
Suggestion, they have suggested.
Not
It
suggest.
is not fact. They have given suggestion, but no evidence as such has laid by him. No evidence. Suggestion is not evidence, my lord. It is disputed question. They have disputed, but they have not given any evidence as to the parking light was on
Which
that
page?
off. That is on record, my lord.
57 to 60, Lordship, in the booth.
PWT. It is not fact.
Yeah.
This is assertive, Lordship. It is not a fact that I saw the parking light was on. Because in their chief, they had mentioned that. In cross, he said that it is not a fact that I saw it on.
You are admitting.
Yes,
It's suggestion only, my lord.
no,
No,
it
but
is.
But they have not given any evidence upon that.
suggestion carries value if it is answered in affirmative.
My lord, they have to lead evidence. Then we would have a chance to cross-examine.
We were
But
not
we have not
present at
given
that
that
place,
chance
Lordship.
because they have not examined any witness upon that negligence, my lord. Parking light, whether parking light was on or off. They have only suggested, given suggestion and finish. There is no on the part of the prosecution. There is no my lord, fault of my lord, contributory negligence. There is no any contributory negligence. Parking light was on.
Okay.
Lordship, I am appealing for a
Yes, Mr. Datta. You are appearing for which? For whom?
for the insurer of the parking vehicle, Lordship.
You have been,
Uh,
no liabilities put.
was imposed on me, Lordship.
What is your submission?
Since there was no rash and negligence on the part of driver of our vehicle, and the charge sheet was filed against the other vehicle, and accordingly, by discussing the issue number 1, rightly has imposed the liability upon the other vehicle, Lordship. Even Lordship consider there is some contribution on contribution, then also as an insurer, since the claim case was filed under section 166 of MD Act, no liability can impose upon me, Lordship, since the person or whom the claim was made, Lordship, he cannot file a claim petition against himself, Lordship, under section 160 of MB Act, Lordship.
Okay. Heard, Mr.
My lord, they have not filed any ejar or information regarding the functioning of parking light, non-lighting of parking light during accident. Neither given evidence nor filed any complaint before the police or any other police on the part of negligence on our vehicle.
Okay.
It was on.
Heard Mr. MP Sharma. No. Heard Miss R.D. Majumdar, the learned counsel for the appellant in MAC appeal number 177/2015. Also heard Mr. MP Sharma. No, MAC appeal number 177/2015, as well as counsel for the respondent number 1 insurance company in MAC appeal number 545/2017. Also heard Mr. MP Sharma, the learned counsel for the respondent slash claimant in MAC appeal number 177/2015, as well as counsel for the appellant in MAC appeal number 545/2017. Also heard Mr. K.K. Bhatto, learned counsel for the United India Insurance Company Limited in both the appeals. Stop. Next para. By this common judgment, this court proposes to dispose of both the proposes to dispose of MAC appeal number 177/2015 as well as MAC appeal number 545/2017 as both the appeals have arisen out of a common judgment. Stop. One of the appeal, that is MAC appeal number 177/2015, has been filed by the National Insurance Company Limited, wherein the liability to pay the compensation to the extent of 100% has been denied. Stop. The appellant in the said appeal has also impugned the quantum of the compensation awarded to the claimants. Stop. Whereas in the second appeal, that is MAC appeal number 545/2017, the claimants have impugned the quantum of compensation awarded to the claimants. Stop. On the ground, claimants, on the ground that the tribunal did not take into consideration the income certificate issued by the circle officer, which was exhibited as Exhibit 6, while assessing the income of the deceased for the purpose of computation of the compensation paid to the claimants. Stop. The next para. The facts relevant for consideration of both the above mentioned appeals, in brief, are that on 28/12/2009 at about 12:30 a.m. the husband of the appellant, husband of the claimant, and there is only one claimant, husband of the claimant, namely late Raja Mohan Bora, was driving a truck bearing registration number AS06B7052. Stop. When the said truck reached Pukan Pukhuri at SUKN Hukanpukri at Sipsagar while going from Dergaon to Moran, he parked the said vehicle on the side of the road for easing himself. Stop. At that time, another truck bearing registration number AS23 slash 23C 9317, which was coming from Dergaon side and was driven in a rash and negligent manner, rammed the truck of the deceased from behind, as a result of which the said truck fell on the deceased, causing serious injuries on his person and resulting in his death at the spot. After the accident, the deceased was taken to Sipsagar Civil Hospital, where his post-mortem examination was conducted. And FIR was also lodged in connection with the aforesaid accident, on the basis of which Sipsagar Police Station case number 662/2009 under section 279/338/304A/427 IPC was registered. After the next paragraph, thereafter, the appellant in thereafter the widow of the deceased, Srimati Benita Bora, who is the appellant in MAC appeal number 545/2017, approached the Motor Accident Claims Tribunal the court of learned additional district judge within bracket FTC number 3, Kamrup Metro, by filing an application under section 166 of the MV Act seeking compensation for death of her husband in the aforesaid motor vehicular accident. Stop. Continue. The said claim case was registered as MSC case number 531/2010. The notices were issued to the opposite parties in the said claim case. However, only the National Insurance Company Limited filed the written statement in the said claims case, denying its liability to pay any compensation. The owner and driver of the offending vehicle, as well as the you were made party, Mr. Bhatto. before the tribe.
Seen the judgment, I was not made party in the tribunal.
Before.
The claimant is the owner of the track, lordship.
Well,
They were made party lordship, they did not appear. Later on, they appeared and did the crossing the.
United, you were made party.
They were made party.
क्या लिखा?
17.
As well as the insurer of vehicle bearing registration number AS23C 9317, that is Messrs. United India Insurance Company Limited, did not file any written statement in the said claims case. On the basis of the pleadings of the parties, the Motor Accident Claims Tribunal framed following issues. Quote A from page 9 in MSC Appeal number 177/2015. In support of her claim, the claimant adduced evidence of 3 witnesses, including herself, and exhibited as many as 5 documentary evidence. Though the United India Insurance Company did not file any written statement, however, it did cross-examine the witnesses of the claimants. Ultimately, continue. Ultimately, by the judgment and award which has been impugned in both these appeals, the claims tribunal awarded an amount of rupees 13,47,500 with an interest at the rate of 6% per annum from the date of filing of claim petition to the claimant. Stop. Next para. Miss R.D. Majumdar, the learned counsel for the appellant, namely Messrs. National Insurance Company Limited, has submitted that the claims tribunal has erred in attributing negligence, entire negligence of the which resulted in the accident on the driver of the vehicle bearing registration number AS 23C9317, inasmuch as he did not consider the admission by the sole eyewitness, that is the PW3, who was the handyman of the vehicle bearing registration number AS06B7052, wherein he has admitted during his cross-examination that the parking lights of the vehicle bearing registration number AS06 B7052 were not on when the said vehicle was parked on the road when the accident occurred. She submits that as the accident occurred in the month of December past midnight, merely because of the fact past midnight, hence past midnight, and the truck bearing registration number AS06B7052 was parked in the middle of the road with parking lights not on. Hence, merely because of the fact that the driver of the truck bearing registration number AS06B7052 hit the said truck from behind. Oh, sorry. Driver of the truck bearing registration number AS23C 9317 hit the truck bearing registration number AS06B7052 from behind. In itself, may not be sufficient to come to a conclusion that the accident occurred entirely due to the negligence of the driver of the truck, which was insured by the appellant insurance company. She submits that a stationary vehicle occupying the road in the dead of night without any warning indication poses an evident hazard to road users, and this aspect was not taken into consideration by the tribunal. She submits that under the facts and circumstances of this, under aforesaid facts and circumstances, it is evident that the driver of the both trucks involved in the accidents have contributed to the accident, and as such, she submits that the appellant insurance company, namely that is National Insurance Company Limited, may be liable to pay only 50% of the awarded amount, as there was apparently contributory negligence on the part of both the drivers. Stop. She further submits that, next para. Next para. The learned counsel for the appellant in MSc, learned counsel for the appellant in MSc Appeal number 177/2015 further submits that the tribunal also erred in computing the assessment, computing the compensation payable to the claimant on a higher side, as it failed to take into consideration that even if the mother and minor daughter of the deceased were taken to be his dependent, there were only 3 dependents at the time of his death, as the father may not be regarded as a defendant in absence of any evidence to the contrary. She therefore submits that the deduction made by the tribunal on account of living and personal expenses of the deceased ought to have been to the extent of 1/3 of the income of the deceased and not 1/4 as done by the tribunal. Stop. She further submits that the tribunal had also erred in adding 50% of the earnings of the deceased towards future prospect, inasmuch as per the judgment of the apex court in the case of Prohibitions का citation लिखना है पूरा, Prohibitions reported in so and so. It is if the deceased happens to be a self-employed person or he used to get a fixed salary, then the addition towards, and if he happens to be less than 40 years, what is the law? 40 years, less than 40 years of age, the addition towards future prospect should be to the extent of 40% of his income.
17, 16, SCC 618.
Stop. She further submits that the tribunal also erred in awarding rupees 25,000 against expenses, against funeral expenses, which is on a higher side than that of what has been directed by the apex court in the case of Pranay Sethi Supra. She submits that in the aforesaid case, the apex court has standardized the compensation to be paid against funeral expenses to the extent of 15,000 only. Similarly, she submits that against loss of estate, against the conventional head of loss of estate, the compensation paid is on lower side by the tribunal, that is 10,000 only. She fairly submits that this compensation may be increased to 15,000 as per the guideline of the apex court in the case of Pranay Sethi. She further submits that the tribunal has also erred in awarding a compensation amount of rupees 1 lakh to the claimant against loss of consortium, as well as rupees 1 lakh to the minor child of the claimant against loss of affection and guidance, as well as awarding 1 lakh to loss of care and affection against loss of care and affection to both parents. She fairly submits that the wife as well as the minor child and parents may be entitled to loss of consortium at the rate of rupees 40,000 each, as was directed by the apex court in the case of Pranay Sethi, as well as Pranay Sethi, Magma का citation ले लेना, Magma, stop. She there accordingly submits that in view of her submissions, the quantum of the compensation, no, काट दीजिए. The learned counsel for the appellant, namely National Insurance Company Limited, further submits that the tribunal has correctly discarded Exhibit 6, which is the income certificate issued by the circle officer, as the author of the said certificate was not examined by the claimant side. She further submits that the said certificate was also issued only after death of the husband of the claimant number 1. As such, the tribunal has correctly discarded the said certificate. She, however, submits that while assessing the compensation, while assessing the income of the deceased, the tribunal erred by assessing the same at rupees 5,000 without there being any basis for the same. She further submits that the accident had occurred in the year 2010, and the tribunal ought to have taken into consideration of the minimum wages payable to an unskilled worker at that time, 2009 unskilled worker at that time, while assessing the income of the deceased in absence of any credible documentary evidence. Stop. She further submits that in view of the submissions made by her and grounds taken by the appellant in the memo of appeal, the quantum of compensation payable to the claimant may be reassessed, and liability of the appellant, namely National Insurance Company Limited, may be restricted to 50% of the awarded amount. She further submits that the National Insurance Company Limited has already deposited the 50% of the original deposited 7 lakhs out of the awarded amount, and she submits that no further liability should be ascribed to the present appellant. On the other hand, Mr. M.P. Sharma submits that the tribunal has correctly ascertained that it was the driver of the offending truck bearing registration number AS 23C9317, which was at fault for which caused the accident as the said truck hit the truck which was driven by which was parked on the road by the deceased. Stop. He submits that the criminal case which was registered in connection with the accident was against the driver of the truck bearing registration number AS23C9317. He further submits that during his cross-examination, the PW3 has only denied the suggestion given to him regarding using of the parking light by truck bearing registration number AS06B7052, and the National Insurance Company did not adduce any evidence to counter the evidence led by the claimant. As such, he submits there is no infirmity in the tribunal assessing the tribunal reaching a conclusion regarding negligence of the driver of the offending truck bearing registration number AS23C9317, which caused the accident. Stop. He further submits that the tribunal, though correctly assessed the liability to pay compensation on the part of the owner and insurer of the offending truck bearing registration number 23C9317. However, it erred in assessing the income of the deceased and consequently computing the compensation payable to the claimant on a lower side. He further submits that though the claimant has adduced the documentary evidence, that is Exhibit C6, which is a certificate of income issued by the circle officer, wherein it was reflected that the deceased was earning an amount of rupees 15,000 at the time of his death. However, said certificate was discarded by the tribunal without showing any reasons for the same in the impugned judgment. He submits that the said certificate being issued by a public authority is a public document within the meaning of Section 74 of the Evidence Act, and as such, same ought to have been relied upon by the tribunal while assessing the income of the deceased. Stop. In support of his submission, he has cited a ruling of the High Court of Manipur Manipur High Court in 1958, whether Manipur High Court was there. So this citation appears,
Citation.
how there can be, but it is written in the citation.
Citation is this.
The citation is doubtful.
Yeah.
There cannot be.
Because of that day it was Gauhati High Court.
Okay. Let me reflect it. You have cited it. No. Okay. The in earlier paragraphs, in support of her submissions, the learned counsel for the appellant has cited a ruling of the apex court in the case of Oriental Insurance Company Limited versus Kaluram and others, reported in 2026 INSC 653. Stop. Next, now, Mr. MP Sharma. In support of his submission, the learned counsel for the claimant respondent has cited a ruling of Manipur High Court. Yes, Mr. Das. Whether High Court of Manipur was in existence? 58.
I don't think so. Because, 1958, where is the Manipur High Court, man?
That citation was collected from the.
Okay, I'll reflect it, then I'll verify. Thank you. In the case of Prithi Singh versus Union of India, reported in 1959. AIR within bracket Manipur 43. Stop. On the other hand, Mr. K.K. Bhatto, the learned counsel for the United India Insurance Company Limited, has submitted that the tribunal has correctly assessed the compensation to be compensation to be payable to the claimant on the basis of evidence on record, and same needs no interference. He submits that the negligence on the part of the driver of truck bearing registration number AS23C9317 is apparent from the from the evidence of the eyewitness, as well as other documentary evidence, including the FIR and accident information report. And as such, the impugned judgment and award needs no interference of this court in this appeal. I have considered the submissions made by learned counsel for both sides and have gone through the materials available on record. I have also considered the I have also gone through the rulings cited by learned counsel for both sides in support of their respective submissions. Stop. Reserved. I am reserving the judgment.
Highly obliged.
Matter is there, my lord.
Supplementary.
Supplementary, my
29.
129. There was some urgency on our part. Coal India may not have urgency, but we have urgency on our part. So
Which matter?
can it be on third, my? কেটে করি
9 তারিখে করি।
10 তারিখে হবে 15 করবো স্যার 10 হলে ভালো হয় 10 10 is Thursday.
10 কি day?
10 Thursday.
Item number?
29 supplementary.
Yes.
Item number 15, this will be taken on.
No, let me pass orders
Yes.
on 29. What is your name? I don't know your name.
B. Doctor.
Heard me.
Vinay.
Heard Miss B. Datta, learned senior counsel, assisted by Mr.
AM Doctor.
A.M. Datta, learned counsel for the appellant. Also heard Mr. D. Das, learned senior counsel, assisted by Mr. S. Khan, learned counsel for the respondent. This matter could not be taken up today due to paucity of time. Hence, let this matter be listed. When do you want?
On 10th of September.
10th is okay.
10th, Thursday.
Let this matter be listed on 10th of September.
My lord, as a I'm not as a first item can be taken because it's a very old matter. 2013 matter, man. 2013 matter.
At 2 we may take
At
it.
two, yes.
At 2 p.m. Yes, Mr. Roy.
15, this will be taken on Tuesday. This last 25 years, the ejectment suit is pending. It is of 2001.
You are for the
I am for the respondent.
I am for the petitioner, Lord.
landlord.
I am for the.
Item number 15.
51.
When can we take it up?
Tuesday,
First,
1st of September is a holiday.
holiday.
Thursday की तारीख है?
3rd September.
3rd September. Heard Miss S. Todi, the learned counsel for the petitioner. Also heard Mr. S.P. Roy, the learned counsel for the respondent. This matter could not be taken up today due to paucity of time. As such, let this matter be listed on 3rd of September at 2 p.m.
See, Manipur High Court was established in 1930, sorry, 1930.
1-3.
Before 2013, before
Yes.
Killing bench from 1972.
No, but the citation cited by the council shows it Manipur High Court in 1958.
Incorrect, might be bench. Outlying bench were there, 1972.
Yes.
My lord, item 19, my lord. I'm just preparing for a death, my lord. Any hearing death, my lord.
Item number 19 already mentioned by somebody. Huh?
No. 17 and 18 mentioned, Lordship.
Okay, 19. 19 will go to December.
My lord, little bit short.
If you want a fixed date, it will go to December.
My lord,
This matter could not be taken up due to paucity of time. Let this matter be listed
My lord, if possible, immediately after Puja vacation, my lord.
after 4 weeks on a date to be fixed by registry.
My lord, then one date may kindly be.
Date, what I am saying, I can give dates only in
That may be fixed.
December first date, lord.
10th of December.
Obliged.
My lord, item number 30, my lord, this matter was listed last Tuesday also. But this is a 2019 MSc appeal, my lord. I'm afraid this matter may be taken up on 8th of September, my lord.
Okay. Heard Mr. S. Chakravarti, the learned counsel for the appellant. This matter could not be taken up for hearing due to paucity of time. Let this matter be listed on 8th of September.
8th of September.
8th of September.
Can it be at 2 p.m., my lord?
No, everything cannot be.
No, my lord, till now, this on 8th, no other
Okay,
case.
8th of September at 2 p.m.
Obliged, my lord.
item number 25, my lord. Though it is fixed for hearing, my lord, there is also an IA, my lord, which was not disposed of, my lord. So my only prayer is that, my lord, let the IA come for orders, my lord, in next week or day next week.
MEC matter.
No, my lord, testamentary appeal, my lord.
Testamentary appeal, we can hear it instead of I.
Well, the IA was for additional evidence, man. So perhaps when that IA will have to be first disposed of, well, order 41 rule 27.
There is an apex court order that you go try to find out it and inform me on the next date fix.
Well,
That when there is an application under order 41 rule 27, it should be taken up along with the final hearing. If court feels that it should allow the additional evidence, then a separate order will be passed in that regard. Otherwise, it should be finally disposed of.
then my lord will hear it together. My lord.
Yes.
My lord.
No, you find out this judgment.
My lord, I'll test that.
We are not giving any date.
May it please your lordship, in regards to item number 16, a date may be fixed, your lordship. It is a long pending matter. The cause of action arose on 2009, your lordship. If a short date may be given.
Short date. Item number 16. This matter could not be taken up for hearing. Listed after 3 weeks on a date to be fixed by registry. Yes.